May I please, Lordship? Lordship, I beg to mention item number 25 for withdrawal, Lordship. We have received instruction, Lordship. With a liberty.
Your name?
8,000, Lordship.
Mr. D. the learned counsel appearing on behalf of the petitioner submits that he has instructions to withdraw the accordingly, the instant with petition stands closed on withdrawal. Interim orders, if any, stand.
Lordship, with a liberty, Lordship.
What liberty?
Want to file it again, Lordship. We have not implemented the necessary parties here, Lordship.
Then we'll see when the matter reaches. You can't come up like this. The cancel, order cancel.
Item 20, my lord. Concern of the petitioner's counsel and the private respondent. My lord, I need some more 2 weeks time to get the instructions, my lord. There was some miscommunication. My lord, the counsel who appeared on that day, he had a death in the family. He had to go to Techpurs. So we were not aware, and there was delay in sending the mail, my lord. There was delay in sending the mail to IOC. So 1 week's time.
Request of Mr.
He Bharadwaj for IOC.
Bharadwaj appearing on behalf of the Indian Oil Corporation. Matter is then adjourned to be listed again on 31st of August 2024. On that day, the council shall positively list the instructions as sought for by this court in order dated.
It's order dated 14th of August.
Item number 16, my lord.
60?
16.
Hmm.
My lord, the other side filed affidavit, my lord. We need to reply to that. My lord,
Huh?
2 weeks time.
For what?
Reply that, my lord, affidavit.
I don't give adjournments for those aspects. We'll see when the time comes, not at this stage.
Fine.
Lordships, I have a prayer with regard to item 45 of the daily list, Your Lordships. This
40?
matter has 45, Your Lordships. This matter has become infructuous, Your Lordships. I may be allowed to withdraw the withdrawal.
Already letter of award issued. Already letter of award issued to the respondent field.
Ms. S. Sharma, appearing on behalf of the petitioner, submits that the writ petition has become infructuous in view of the letter of award being issued to
To the respondent field.
the respondent number 3. And as such submits that she would like to withdraw the instant. She has instructions to withdraw the instant writ petition. Accordingly, the writ petition stands closed on withdrawal. Interim order, if any, stands vacated.
My please, Lordship. In item number 41, I have submitted an additional affidavit, Lordship, on 19th. It may kindly be called.
With regard to item number 50, we have to file 50.
Huh?
50. We have to file an affidavit with regard to completion of dusty service. That is being filed today, my lord. Can the matter be fixed next week, my lord, if possible, man? Affidavit with regard to dusty, my lord, that is being filed today, my lord. 7 or 28, my lord, next week, if possible, my lord.
You have to take fresh service. You have to take fresh steps. How can I fix another date? You have informed, I have fixed a date, particular date. And on that date, you have informed, thereafter, there is no date fixed. If I fix another date, you have to take fresh dusty service in view of your failure to file the affidavit of service on or before.
That is filed today, then let the matter be reached.
Let the matter reach. Yes.
In item number 58, my lord, IA we have filed 58. That may be requisition, my lord.
Where is 58? I don't have 58. I have only till 57.
Oh, sorry, that 56, my lord, sir.
What is this? You are not there. HR Ahmed is there.
Item number 56.
Yes.
Oh, I am then sorry, my lord. Then in item number 8, my lord.
Don't come out like this. When the matter reaches, don't come up with this thing. Keep on choosing whichever matter.
I beg to mention for listening for withdrawal, my lord. Kindly tomorrow,
Okay,
my lord.
next week. What tomorrow? Next week.
File an IA, my lord, for implement petition. Kindly allow for the IA along with item number for
40? 44. I for what?
but we have filed in 19/6/2024.
Your name?
B das
E. Das. You are not there in 44.
to Som T Som.
It has been submitted by the council appearing on behalf of the petitioner that an interlocutory application has been filed in the said instant contempt proceedings. List the matter again on 18th of September 2024. In the meantime, the registry shall bring on record the said interlocutory application.
Number 1.
Matter may be, possible about a time being, Mr. Arbor Fusari will appear in this matter, Lordship.
Mr. Bora,
To know that there's some consultation between GMD and the petitioner. My lord. And there is some exchange of agreement, how the draft agreement is going on. My lord. Ultimately, they have to sit down and boil to particular how the arrangement had to be made. When I have seen the draft agreement, there is nothing in that, whether the which schedule, amount of consideration is not there. So they have to, both have to sit down.
Huh?
Both have to sit down and come to how the agreement will be done. Even I was informed that day before yesterday, they have made and they have come to some conclusion. Ultimately, conclusion has been done that this land will be taken over by GMDA, that consideration part, area part had to be done.
but how you take care of a situation where some patta which was issued to you was cancelled in view of non-payment?
That's there. Now, my lord, if this arrangement works out, my lord, we will forego that particular patta because that patta, your lordship will recall, was shown as retainable, no notice, it was put to auction sale. And there, my lord, there has been some allotment, not exactly a settlement in respect of some Hongram committee. So if this arrangement works out insofar as patta number 9 is concerned, we might as well forego that. My lord.
But don't you think that the order by which patta you have been given in patta number 6 or 13 or something, it has got auction or something.
Yeah.
But what about the 9?
9 is still Sarkari.
So unless we make it
Exactly, my lord. That has to happen first.
your land,
Yes.
the question of they taking out, how can they take away? Or how do you enter into an agreement? Tell me.
Yes. That's the difficulty.
Maybe a case of a tripartite agreement, but that has to be on the basis of some finding by this court that you should have been given 9, not that.
But I see it this way, my lord. If, of course, the revenue has to come on board. And if the revenue says that it does the correction, reverts it back to my name, then I can enter into an arrangement with GMD.
Otherwise, as of now, you can't.
I cannot. But once the revenue does the correction, other way to do it perhaps would be, I'll have to take instructions on that. That we enter into an arrangement since the land is already Sarkari. We sort of abandon our claim for a consideration. And therefore, since the land is Sarkari, it can again be allotted to GMDA because on paper it is still Sarkari.
Then they will, the government will have an audit problem.
Those aspects of course.
Government will have a problem that if it is a Sarkari, why the GMD is paying you money?
Those things have to be worked out. Now
The payment of money will only arise subject to you having some
Yes,
right.
yes.
Unless this court gives a finding that it has been wrongly done, or the revenue admits the mistake and corrects it on its own, then reverts it and then gives
Then
it.
that's the best.
That is the only way out. Otherwise, this court has to hold the 9.
Yes, or else the final statement has to be set aside. Now, if the final statement is set aside, then the state will have another difficulty with the other part. where I'm otherwise ready to forego, provided this arrangement. So which is why your lordship has suggested the negotiation part of it.
I therefore suggested negotiation insofar as you and the district administration, so that unless that is not worked out,
Yes.
other consequential things of the GMDA and all would have
Yes,
no value,
that's-
although they may be interested or whatever may be, but that has to be taken note of.
Right.
It will be very difficult otherwise. Because I thought about it, it will be very, otherwise it will be a problem. Because they cannot give you money when it is Sarkari, unless there is a finding by this court to that effect. That there it was a mistake making it 13, it should have been 9. And if this court gives a finding on the basis thereof, they can very well work
Then
out.
I may not, then it becomes my land.
Anyway, but as of now, one land is already auction sale and the other land is this. One land, that is why the other land, one land which has been auction sale has been done on the basis that you did not pay the year. But you did not receive notice
I did
also,
not
and there is no
receive no-
challenge to the auction sale also, because you don't want, because you are not interested in that land.
So, my lord, the best possible way, my lord, is if the revenue admits the mistake, reverts it back on the condition that I will eventually hand it over to GMDA.
That is the only way out. Don't you think, Mr. Bora?
Ultimate-
Otherwise, there is a big problem. You will have a problem.
Yes, but the
Audit.
money will be released to whom?
And if you enter into an agreement today, tomorrow the audit will catch you.
Yes,
Says, why did you pay any amount? Because
Yes,
as of now, it is Sarkari.
certainly.
Because they want to otherwise do it under a land pooling scheme. So for us to avail that land pooling scheme also, I have to be recorded as owners probably.
Somewhere something, as your rights have to be given somewhere. If your right is not given, tomorrow they may, today Mr. Bora may convince his client to do so, but tomorrow that client will have a problem.
Yes. All will be audited, my lord. Where the money
Ah,
has gone, all
At
the
the
track will
end
be
of the
there.
day, it will be audited. How did this happen?
How did it happen? Who paid where, who signed it later on, they will be in trouble.
And some other judge may come up and later on say that this is not done, take the money from the airing officials,
That's it.
along with the advice given by Mr. Bora, take it money from him. Huh? We'll do anything, we'll take it up again at 2. Huh? He's not here.
Okay. Obliged.
Go to promotion. Notice me.
You are GAC.
Yes.
You are also a government advocate.
Yes.
Find out why this has not been done. What is the problem with this deputy director of what? What is his name? This official who have been directed by this order? Deputy Director of Food and Civil Supply. What is his problem in passing that order?
Just the change of name.
So what? No, change of name or whatever may be, there is a direction passed by this court.
Consider it one way or the other.
Rightly or wrongly, why their order is not being passed?
And now the stand.
You give a copy to her.
Person is.
Who is appearing for the government?
There's
food
no
and civil
government, but it's
supplies.
My name, that's the reason I can.
No, not for you. Therefore, I can't. Who is appearing for the civil supplies?
Food and civil supplies, Simantini.
We have declared lordship, but this is content. We are.
I know what is
Yes.
contempt or not. Ask your deputy director, whoever it is, to comply with this order of 22/9/2019. Rightly, whatever the order is, that there is an application file. The application is required to be disposed of. That's all. What is the problem? Ask him, I'm fixing it on 9th of September. Ask him to pass that order. Else I'm going to issue notice. And once this court issues notice, you are in trouble. I'm telling him. Tell that official. Along with you, you are also government advocate. Tell him.
He has.
I want to close it.
This man has retired. This man has retired.
I'm not concerned with which man. ABCD, I'm not concerned. I'm concerned with the deputy director of
Yes,
foods and
that-
civil supplies.
That my learned.
Whoever it is. Bongaigaon, ask him to pass the order in pursuance to this on the application file. Once it is being passed rightly, wrongly, we'll close this petition. Unnecessary keeping all these matters out here makes no sense. Ask him.
Yes, that's.
This court had requested Miss S. Bulwa, a learned junior government,
Yes, that's.
junior government advocate, as to why the order dated 22/2/2019 passed in WPC number 1165/2019 has not yet been complied with. List the matter on 9th of September 2024.
Copy of the petition and order of this court. Time.
We will give it to you. This is, I'm not recording anything in the order. You see to it that this is done. We close it on that date. The registry shall reflect the name of Miss S. Bulwa in the cause list. Yes, what is this?
If your lordship goes to the last order, lordship, 29th of July, lordship,
Ah, what is happening?
all for,
Huh?
along with the CD, lordship.
What? Understood. Everything is understood. Now what is happening?
Yes, Lordship.
What is the status report?
I have received the status report and that report is also there.
It is okay. I'm not on those. What is your status as regards finding out the girl? That is the question. Whatever you do, that is your. Earlier on, you said that you are not in a position to trace out the girl. It
Yes.
was given to the CID, it was given to the what? Whom it has been given. Why the girl has not been traced out?
Yes, there's an investigation going on.
Understood. What is the investigation? How many photographs are there in the mobile? I'm not concerned with that. It's not for this business. Question is why you have not been able to trace out. 2022, this incident
Yes.
happened. We are 2 years down the line. Why it has not happened? Come up with all these things. What are these?
Record is case diary. and
Record
so
case diary and keep it all. File your affidavit and give us why you have not been able to, or let the government of Assam or its investigative in the agency say that we put our hands up, we can't find, we don't have the capability. File an affidavit to that effect. Then we may explore the thing of giving it to the CBI. But the delay in the matter would only be prejudicial to the victim, isn't it? There has been no notice issued. We issued a notice. Issue notice making it returnable on 13th of September 2024. This S. Burwa appears on behalf of the respondent numbers 1, 2, 3, and 4. The petitioner herein is the, who is it? Huh? You're the father.
Who is the father?
Father. Petitioner herein is the father of, what's the name of the girl? Huh?
Nilima Singh.
That's the petitioner name. What's the daughter's name?
Is A. Nilima Singh, lordship. Petitioner name is A. Nilima Singh.
Where do I find that? Yeah, Nilima. And your, yeah, okay. The petitioner is the father of one A. Nilima Sinha. And his daughter, as claimed in the writ petition as well as the FIR, have been missing since 25/10/2022. 24 or 25? 24. 10/2022. Thereupon, an FIR has been filed the petitioner is unhappy with the investigation so carried out, taking into account that the respondents herein, including the SIT so formed, have not been able to trace out his daughter. It is under such circumstances the petitioner herein had approached this court, taking appropriate directions for transferring the case for proper investigation, for constituting a special SIT by this court, as well as and or transferring the case to the CBI for proper investigation. This court have also taken note of that there are certain orders passed by this court as regards seeking the status report of the investigation and the manner in which the investigation has been carried out. It is the opinion of this court that as 2 years have already passed by, any delay in carrying out the investigation further would be detrimental to the interest of the victim. In delay in carrying out the investigation for tracing out the missing daughter of the petitioner would be detrimental to the interest of the victim. Under such circumstances, this court directs the respondents herein to bring on record their stand as to whether they would be in a position to carry out the said investigation for tracing out the daughter of the petitioner. In the present manner in which the investigation is being carried out. The said stand be brought on record by filing an affidavit by an officer not below the rank of the Special Superintendent of Police, CID, na? Well, a special Superintendent of Police. The rank of Superintendent of Police. Huh? List accordingly. Come up. And Mr. Counsel, you want the matter to be sent to the CBI. Why haven't you made the CBI a party? Why? Why? What?
They feel that there has no role to play also.
What no role to pay? How would this court at all direct the CBI to carry out the investigation? Whom can I issue a writ? I have to issue a writ to the CBI if your second prayer is to admit it. Don't you think so?
Lordship will direct the government of Assam to hand over the case to the CBI also.
My goodness.
Lordship, then I will implement the CBI as party.
What you do, whatever you will. At the end of the day, you will have a problem without the CBI. Because this court has to issue a writ also to the CBI. I may only direct this government to hand over. Then what will happen? The CBI is not bound. How would the CBI would be bound?
So I will make the.
Hello.
Lordship, on last occasion, provided time, Lordship, for taking instruction. Several times petitioner went to the office of the circle officer, Lordship. On last 10, during the pendency of this writ petition, also she went.
You have been evicted,
Evicted, Lordship. My house has been.
but not in 403.
3.
The land, they have evicted you as 405
Serving notice for 405.
and evicted you.
Evicted, my house has been also demolished, Lordship.
So
And I
first, don't you think there is a requirement of a demarcation?
Several times this is the illiterate lady, Lordship. Several times he approached the circle officer for any, is there any order for eviction, anything else? They are denying, Lordship. Is there any order?
No, you
for
have
eviction?
included the notices.
Yes, Lordship.
Then
For eviction last on 14 to, they had evicted and demolished my house, Lordship.
and then how many notices has to be issued?
That is their Lordship. Notices were for 405, Lordship.
405, not for 403. So don't you think, therefore, your case should have been that your case is that you have been evicted from 403, not from 405. So therefore, don't you think that a direction should have been issued to the, or a request to be made for making a demarcation in the
Lordship. Lady Angutha Chap, she is not aware of this complicated technical things, Lordship. Huh?
issue notice making it returnable on 25th of September 2024. Ms. So-and-so appears on behalf of the respondent number 1 and 2. Ms. Esbodwa appears on behalf of the respondent number 3 and 4. Taking into account that all the respondents are represented, extra copies of the writ petition be served upon them during the course of the day. The case of the petitioner herein is that the petitioner, along with her relatives, along with others, are the joint owners of a plot of land covered by dark number 403 of patta number 15 of village Mosdia lot under Revenue Circle, Khottebari, in the district of Borpeta. The petitioner had built a dwelling house in the said land. It is the further case of the petitioner that the responding authorities have evicted the petitioner in the name of carrying out an eviction in respect to dark number 405, which is a government dark. Under such circumstances, the petitioner have sought for appropriate directions to the respondents for reconstruction of her dwelling house or to pay compensation. This court directs the circle officer whatever revenue circle, who is the respondent number 4, to carry out the demarcation as regards dark number 403 and 405, and thereby submit a report before this court on the next returnable date positively. As to whether the land of the petitioner in dark number, whether whether any eviction was carried out in respect to the land of the petitioner contained in dark number 403 and which is included in patta number 15, or in dark number 405, which is the government land. Ms. S. Purva, appearing on behalf of the respondent number 3 and 4, shall duly inform the respondent number 4 for effective compliance.
Chief Developer.
Yes, what is this case?
For that, I'd just like to apologize if there is a mistake in the writ petition. The impugn order, which is dated 18/6/2021, inadvertently, because of our mistake, could not be filed, though there is a reference of it in the writ petition. I could not file it, so that's the first apology for that. I have the order, I can pass it on to your lordship because it will be required. I'm extremely sorry for that. It was our mistake.
Yes.
17, the allegation of the department is that I have suppressed the actual value of service that was provided, and consequently, I did not pay the service tax of 30 lakhs for the period. Now, this information apparently they have collected from the income tax department because I have filed my income tax for 11 crores. Subsequent to this, I have paid my tax. They have issued a notice, a show cause notice, your lordship. That notice is of 2021. I was then called for the first time in 2024. But the representative went on 2 or 3 occasions. I could not submit the relevant information in the document because the AR who went was not well. I sought for a permission. I said, please give me some time. I'll submit all the documents in regards to the discrepancy that has been pointed out in the show cause notice, and I'll also file a reply if required. I came back from my treatment. Subsequently, I have discovered that this order has been filed. Now, my only grievance is that I was requested is that I should be allowed to prove whatever I have, whatever the notice says in terms of my documents, because these documentary evidence are important to show why this tax has come into the picture. And in the order, your lordship, which has been filed now, which is
You have a file, you have to file an appeal.
Your lordship, this will always come on my way because the evidence will never be able to be produced on my end.
Why didn't you file your so-called reply?
I could not, and that's what I'm saying, your
You
lordship. I
couldn't
could
means,
not.
did you stop
the-
your business?
I
Were given some time to file your reply.
Yes.
Where is your so-called reply?
I could not file it. That's those 2 letters that I have issued. Your
Where's your
lordship.
so-called notice?
Yes, your lordship.
The
That's-
so-called notice was issued in 2021.
Yes.
And why didn't you submit your reply?
Was never called. I was first time calling.
No. You were asked to submit this so-called notice without prejudice. Here it is say, if no so-called is shown against the proposed action to be taken and so, is required to produce at the time of show causing all evidence which he intended to end the defense. You are to reply to this. Why haven't you replied?
This show cause notice was never, I mean, there was never acted on it. In
What?
fact,
No, I never acted. When
never
a show
acted. I
cause
was called
notice
for the
have been
first time
given.
called in 2024.
What do you want? When did you receive this?
This was sent to me, the notice is your lordship's at page, annexure 2, page 37.
When did you get this
The impugn
order?
order, I think, is 2 days afterwards when I went to the department. This order is of 18/6/2024, June. I came back and I received,
26 July.
no, this is the impugn order, your lordship, which is.
I'm saying about the impugn order. You still have time.
18/6 June.
File your reply, file your appeal.
Your lordship, just give me one opportunity to go before that. I'll
This-
keep it.
Dismiss with cost?
Post judicial hearing, your lordship. please.
Absolutely no, nothing
And
to.
may I just point out one paragraph of the,
Absolutely, you have been given 3 opportunities.
I agree,
Then
but one of the
you,
reasons I've
did
explained.
you
your
stop your business, Mr. Pukon? Did you stop your business during this period of time when the AR was not there? Then How can you take up these type of pleas? This is an absolutely encourages plea.
Your Lordship, it's mentioned in the order. May I
All
just
this
take
while
2
I've
minutes
been
of your
taking
lordship's time?
bench five, seen so many matters, but this is the utmost.
May I just read one
You
paragraph
have
of the order?
taken
Your
things
lordship, will
for
I leave it at that?
granted.
Just 3
Can't be
lines. and I
no,
leave it.
nothing doing.
Just 3 lines.
You were asked to submit your reply, you have not submitted your reply. That's all.
May I just read one part of it? That's all I leave it to your lordships. I'm only requesting if it is not inconvenient, just 2 lines. I leave it at that. Just 2 lines of the impugned order. I'm extremely grateful. 3, that's at internal page 5 of that order, your lordships. Where the finding is there. It starts from discussion and finding, internal page 4.
Yes.
This is para 3.8.
3 point. Yes.
Sorry, I'm extremely sorry. 3.3. I'm extremely sorry. 3.3. This is around 6 lines from the top. 3.3. This is the finding, your lordships. The service provided for which they have received a differential amount of 2 crores may be falling under the negative list, falling under the negative list, or may be covered under the mega exemption notification. In the instance case, in absence of documentary evidence to prove otherwise, I hold that the differential amount of so-and-so receiving is taxable under so-and-so. That's all I'm saying.
So
Just
what?
one opportunity that I should be able
Nothing
to
doing.
provide it, the documents.
Dismissed with cost. Heard Mr. R.B. Phukan, the learned counsel, appearing on behalf of the petitioner. Miss, you are appearing?
And Kapote, on behalf of SCCAL,
What?
on behalf of SCCAL.
He has given you a wakalatnama? How are you appearing? None appears on behalf of the respondents on call. Full stop. The writ petition, the instant writ petition has been filed by the petitioner, challenging the show cause notice dated 22/10/2021, as well as the order in original dated 18/6/2024. Full stop. It is relevant to take note of that the petitioner was issued a demand cum show cause notice dated 22/10/2021. Asking the petitioner to show cause as to why service tax, including cess amounting to rupees 30,19,653 for the period 2016-17 should not be demanded and recovered from him under the proviso to Section 73(1) of the Finance Act 1994, read with Section 174(2) of the CGST Act 2017, along with applicable interest and penalty. There is no denial to the fact that the show cause notice was received. However, the petitioner chose not to file any show cause reply. It is further seen that on various occasions, the petitioner was asked to appear by issuance of notice. As is apparent from Annexure 2, Annexure 3, Annexure 2 and Annexure 3 of the writ petition, thereby fixing a specific time for giving an opportunity of hearing to the petitioner. However, it is seen that the petitioner did not avail the opportunity on account of certain treatment of the petitioner. However, there is no documentary evidence in support thereof. It is further seen that on 18/6/2024, the order in original, which have been impugned in the instant proceedings, have been passed. Thereby confirming to the demand of service tax, including cess amounting to rupees 30,19,653, along with the applicable interest and penalty. And additionally, the applicable interest and penalty. It is further seen from the said order that the order was received on 26th of June 2024. At this stage, this court, however, finds it very relevant to observe that the said order, impugned order dated 18/6/2024, is not part of the record of the instant proceedings, but the same was duly handed over during the course of the hearing. In the said order, a perusal of the said order also shows that an appeal can be filed against the order dated 18/6/2024. To the Commissioner Appeals, Customs and CGST and Central Excise (NER) GST Bhavan. In the backdrop of the above, the question therefore arises as to whether this court should at all entertain the instant petition, taking into account that an efficacious remedy is available. At this case, this court finds it pertinent to take note of the observations of the Supreme Court in the case of PHR Invent Educational Society versus UCO Bank and others, reported in 2024, 6 SCC 579, and more particularly to the observations so made at paragraph number 32. Particularly at paragraph 23, which is reproduced here in under. From a perusal of the above paragraph, it would be seen that the High Court should not ordinarily entertain a writ petition under Article 2 to 6 of the Constitution if an effective remedy is available to the aggrieved person. The Supreme Court further emphasized that this rule should apply with great rigor in matters involving recovery of taxes, cess, fees, other types of public money and dues of the bank and other financial institutions. It was further observed that though the powers under Article 2 to 6 of the Constitution are of widest amplitude, still the courts cannot be oblivious of the rules of self-imposed restraint evolved This court further finds it very relevant to take note of another judgment of the Supreme Court in the case of Godrej Sarali versus Excise and Taxation Officer cum Assessing Authority and others reported in 2023 109 GSTR 402. This judgment is being duly referred to by this court, taking into account as to under what circumstances the writ court can exercise in spite of the availability of alternative remedy. In the same judgment, the Supreme Court observed that in cases where, number one, the writ petition seeks enforcement of any fundamental rights, semicolon. Number two, where there is a violation of the principles of natural justice. Number three, where the order or the proceedings are wholly without jurisdiction, or semicolon, or semicolon, where the virus of the act is challenged, semicolon, or where pure questions of law is raised, then in such circumstances, the court can exercise the writ jurisdiction in spite of the availability of the alternative remedy. In the backdrop of the above, let this court take note of the case made out by the petitioner. From the facts narrated above, it would be seen that the petitioner received the show cause notice in the year 2021. 22/10/2000, show cause notice dated 22/10/2021. But the petitioner did not take that opportunity of submitting a reply. It is further seen that the petitioner was duly given opportunity for personal hearing. However, the petitioner did not avail such opportunity. Under such circumstances, the question of violation of the principles of natural justice do not arise. In addition to that, the other parameters when the writ petition can be entertained is not met in the instant proceedings. Consequently, therefore, this court is not inclined to entertain the instant writ petition, for which the same stands dismissed.
Takes.
Kindly put the timing for the.
What?
I'm appearing on behalf of, yes, of one of my colleagues, my lord. He's in another court.
What are you asking for?
The timing possible. For the timing.
This is absolutely a dispute between a civil dispute.
Not in this case, my lord.
Oh, now it appears we have it after in the month of October.
Timing.
Time being.
This petition has been filed, Lordship, being agreed by the order of page, Lordship, 52, by which the NOC granted was cancelled, Lordship, by the Silchar Municipal Board, Lordship. Now, I have filed an appeal that is pending before them, Lordship. One aspect of the matter, this, Lordship, some instructions came later on that. The power of attorney on the basis of which I obtained license, that has been withdrawn, but that is not reflected in the impin order. An agreement.
No. 321 powers executive officer cannot execute. Cannot do so. So, merely because an appeal is pending, if that provision is not because of the dissolution, it cannot be done. So for you, therefore, you are to come before this court and challenge that order which have been passed. Now, what is your case?
Lordship find that one agreement was entered between the petitioner and the respondent number 4, who is my sister.
Where?
Lordship find it page 17, Lordship. An agreement for development of the land along with the power of attorney. Now, this agreement has not been cancelled, but it appears that some application has been filed by the respondent number 4, which copy was not served up to me, Lordship. I don't know on the what basis he has raised an objection, Lordship. And that.
Isn't this a case purely a civil dispute?
Lordship,
As of now, this court cannot stay because the moment I stay that order, it will have an impact on, it is already cancelled. So I can't stay it.
the agreement's not been there. That is not reflected in the imprint order also. But what the reason is getting reason stated is that there is no boundary. This means, Lordship, the demarcation and all. Whose share is one? That is not correct, Lordship. We are 8 sisters. We are 4 brothers and sisters. Others has sold out their land. It's an inherited land from my father, Lordship.
Inherited lands from?
My father was the owner.
And what
proprietor.
happened? Let us see the order. Where is that order? Annex 7.
Page 52, Lordship.
Was initiated on the application filed by the complainant, alleging that opposer obtained construction permission on concealment, and while application for construction was made, the land of the complainant was shown to be the land of the opposite party. On receipt of the application, the proceedings were initiated and the notice was issued to them. The notice was sent through the regular process through police, and the same was refused to be taken by the fact even after the receiving the notice through the police, the office did not appear for hearing also, and therefore thereafter the notice was served by hanging in the conspicuous. In spite of receipt of can't help it. Why didn't you appear?
Chip.
Why didn't you appear?
That status showing by paragraph 10, Lordship. I have not received any notice except one reminder letter, Lordship.
So then did you contact?
After that, I filed, Lordship, page 50, Lordship. The agreement and the
With
power of
reference to
attorney.
your letter, I am submitting the copies of permission. That means you participated.
But that has not been considered, Lordship.
Huh?
It appears that the agreement and the power of attorney that were not considered.
No, whatever may be, the finding arrived at is that there is no division of the shares. And as such, you do not have a right, the total right over the land. See the last portion? But the land inherited by the heirs of so-and-so, including the complainant Binalala and so-and-so, still remains undivided. And no specific shares have been demarcated. There is a variation between the land shown in the construction permission from the existing one. Thus, the material concealment with regard to the quantum and boundary of the land is pretty much visible, and the construction permission is apparent to be granted on the basis of misrepresentation made by the opposite party. In view of the above, there is no option for this authority but to cancel the construction permission so and so for all purposes with immediate and according to the yes. Did you make any construction?
Pillars were raised, Lordship.
Only.
13 pillars,
Huh?
13 pillars were raised.
Only. Nobody is staying.
Lordship, can you come to paragraph 6 of my petition, Lordship?
What? You
If-
did not file your reply. Why?
Was filed on the basis of which we each of us get the share on the basis of degree, and a family settlement was entered on 30/12/2016.
Where? Page
Page 6.
of?
Petition.
That is the
paragraph
most
6.
vital document. Why haven't you enclosed?
Paragraph 6, I've stated. first.
Why?
Let me find.
Why
that-
paragraph 6?
Let me find that through an affidavit.
No, this is not complete.
Let me bring their Lordship, filing an
The B.
affidavit.
Chakraborty, the learned counsel appearing on behalf of the petitioner seeks a week's time for filing an additional affidavit to bring on record the
Degree of the petition.
decree passed in a partition suit as mentioned in paragraph number 6 of the writ petition. Paragraph number 6 lists the matter again on when? 9th September.
Public.
Petitioner before Lordship Mallet, the Patata Mallet, and he has constructed his house Mallet on the state plot of land Mallet. Subsequent Mallet on what happened on 14/7/24 Mallet. Some of the purchaser Mallet who had purchased the land from the co-partner of the petitioner Mallet, they had entered the house of the petitioner, demolished the house Mallet, and they took possession of the Mallet land Mallet. Now Mallet being aggrieved Mallet, having no other, petitioner is a widow Mallet. She is a widow Mallet. She had approached the police station Mallet, Chief of the police.
What is the police going to do?
Mallet. Mallet.
Gee, what is the police going to do?
Mallet petitioner had the accused person Mallet had demolished the house Mallet and ill-treated the petitioner also Mallet. And entire house Mallet, I have and is the photograph of the demolished house Mallet. Trespass the house Mallet. It is a criminal nature Mallet.
Then why you are not going under 156(3)? Why you are not going there? Or filing a proceedings before the, what do you call it? The Land Grabbing Act? Why you are not filing all these things instead of coming out here? At the end of the day, you will require that. The police can't do anything. Your only problem is that as regards the land grabbing. Why you are not filing the land grabbing case?
Not only agricultural land Mallet, petitioner is
What agricultural land?
Mallet, if
Are you saying that the Land Grabbing Act is only for agricultural land? Then why you are not filing that? I don't understand that. Why you are not filing 156(3) if FIR has not been registered? Why you are not filing that? Or not filing this application, but filing a land grabbing proceedings? That is the advice you should have given. Filing out here, what is this court going to do at the end of the day? They may direct, you could have got that direction there. At the end, they can't restore. This court can't restore you the possession. You will require a decree. Somewhere you need the best opportunity is the land grabbing proceedings. Why you dealing all these things?
My lord, they have not taken over the position. They have demolished the house. They have not taken the position, but demolished the house, my lord, and bounded post, my lord.
Huh?
They have not taken over the position, my lord. But they have tried to take over position. They have demolished the house and left, my lord. My lord, photocopies I have annexed, my lord. Photograph, my lord.
Then how can this court pass an order without those people being made a party?
My lord, since my lord, I have annexed the copies of the FIR, my lord, that had all, which was sought to be registered, my lord. My lord, in that FIR, my lord, the names of the accused persons are there, my lord.
Huh?
The name of the accused persons who, those.
Understood, but why they are not party here?
My lord, since my lord, I am Imperial Lordship, my lord, only for a direction to register the case, my lord.
No. You want that too is a case of dismissal, the first prayer. I'm not that. But how do I give you the second one? To provide you protection?
I may be allowed to include those persons, my lord.
You go to 156. Let me pass that order, allowing you to go. When did the incident happen?
14/7/2021.
14/7. Then it will go by 175, I suppose, of the BNS. Good.
NSS.
Section what? 175, na? BNS. ওলাইছিল না তিনিখন কিতাপ heard Mr. S. Hawk, the learned counsel, appearing on behalf of the petitioner. Ms. S. Borua appears on behalf of the respondent numbers 1 to 4. The petitioner herein is aggrieved by the inaction on the part of the officer in charge of the Sipazar police station, as well as the superintendent of police Dorong, Mongoldoi, to register the first information report lodged by the petitioner on 21/7/2024. It is also seen from the records that the petitioner herein have also issued communications to is agreed by the inaction on the part of the officer in charge of the Sipazar police station for non-registration of the FIR lodged by the petitioner on 21/7/2024. Also, it is seen from the records that the petitioner initially submitted the said first information report on 21/7/2024. And thereupon, as there was no action taken, the petitioner submitted an application, submitted the said FIR, submitted a copy of the said FIR to the Director General of Police, Guwahati. Stop. The learned counsel appearing on behalf of the petitioner submits that in view of the judgment of the Constitution Bench of the Supreme Court in the case of no, the other one. No, it's Constitution where it says that the FIR has to be lodged, registered. Lalita Kumari versus so-and-so, reported in so-and-so. As a perusal of the said FIR makes out a case of a cognizable, has made out a case of a cognizable offense. The respondent, more particularly the officer in charge of Sipazar police station, was statutorily obligated to register the said FIR. And therefore submits that as the respondent authorities have failed to do so, the petitioner has approached this court. This court have duly perused the copy of the FIR, which have been enclosed as Annexure B to the petition. From a perusal of the said document, it transpires. From a perusal of the said FIR, it transpires that a case has been made out. A cognizable case has been, a case of a cognizable offense is made out. And it prima facie appears that a case of a cognizable offense is made out. In that view of the matter, this court finds no reason as to why the respondent, more particularly the officer in charge of the Sipazar police station, had not registered their FIR. Accordingly, this court disposes of the instant petition, thereby directing the officer in charge of the Sipazar police station to forthwith register the said FIR filed by the petitioner on 21/7/2024 upon service of a certified copy of the instant order. It is, however, made clear that with the above observations and directions, the petition stands disposed. It is, however, made clear that the observations made herein shall not affect the officer, the investigating officer, while carrying out the investigation of the investigation pursuant to the registration of the FIR. At last you found out. Which is your number of your case?
I can wait.
Eh? What is your
Here,
case?
my lord, said I'm morning, my lord, I was to take time, my lord.
Not
The
to
annexure
evict the
I is
petitioner.
wrongly typed, my lord, that has to change, my lord.
Huh?
Annexure I, which we have enclosed, my lord, here, my lord. Is the line in the second paragraph is wrongly typed, my lord. Here it should be a Cotton College, my lord, and here we have, it is typed out as Superintendent of Police Vigilance and Anti-Corruption Department. So annexure itself is wrong, sir. We have to allow to change this FIR, man. Sorry, change this annexure, man. May be allowed one, liberty may be granted.
Which one?
Annexure I, page 46.
What is this?
I'm very sorry, my lord.
Petitioner receipt, notice. Kanoni. Cotton Biswavidyalaya.
Cotton Biswavidyalaya, and we have this is wrongly typed, my lord.
What did you write?
It's a petition filed by the petitioner, Superintendent of Police Vigilance and Anti-Corruption.
What? Where?
Second paragraph, page 46. It should be Cotton College, my lord. আবেদনকারী পঞ্জীয়ক কটন বিশ্ববিদ্যালয় পানবাজার গুয়াহাটি.
Okay, so you want to file an additional affidavit?
Or if your lordship allowed to change it, then we'll change it, my lord.
How?
And if
I
allowed,
can't allow you to
then
just
additional
tear this thing out and all.
then we may allow to file additional affidavit.
But lordship, apart from the translation jolt, the basic contention of the petitioner is that he is apprehending eviction from the government khas land, and that is based on the notice which has been served 1 year back. And after that, he has been called for a hearing to ascertain whether the land is under encroachment or not. So for that matter, if your lordship goes to the notice, this is of 2023. And the hearing was also scheduled on the next month. So for that matter, at least we need to have the status of the land and what is the present status.
Why should this court at all entertained? Why?
No, my lord, hearing not yet done, my lord, till at any moment we may be evicted, my lord.
That is an apprehension.
If you are evicted means hearing, they will convey you the order and evict you.
Well, since 87, my lord, we are staying in the Obasan land.
Huh?
Since 1987.
What land is that?
Land is, my lord, government khas land, my lord.
Aslan, you guys you may not be evicted.
Yes, my lord.
Where is that?
That's why notice has been
So
issued.
show me the
All these
notice.
persons, my lord.
Where?
That is Janoni, my lord. Janoni itself says that we have been called for hearing. Hearing not yet done. I don't know
On
from where that.
38, 2000, a hearing will be fixed to
Yes,
free
my
for
lord. We have been called for here. At any moment, anything may be done.
I beg to state that I am enjoying possession over the said land with the family after constructing
electricity
houses
connection,
since
all
the
over
year
the- we are staying
90.
there,
We
man, over
applied
that
before Iman. We are indigenous people of the locality and entitled to get settlement. Did you apply for settlement?
Yes, my lord. Kopala, we have submitted, my lord.
Again, you are writing, it is to be mentioned that the land was not allotted in the name of vigilance and anti-corruption
That is the thing. Some
everywhere,
Yeah.
not
There is a
everywhere.
So we have to
Hmm.
allow to correct.
Recently, we applied for allotment of the land before the year under Vasundhara. We have enclosed.
We applied, my lord.
Then what happened? This was done
Nothing,
almost
nothing
one.
done, nothing done.
No, they will dispose it of within 333
days, but
days.
Nothing we got, my lord.
Then,
It's remained like that, my lord. Now
Hmm.
hearing also not done.
hearing not done, it is again mentioned in page 53. You have to withdraw this and file a fresh one. How many times you have filed?
Yes,
Everywhere you have mentioned.
I'm well up with the man.
Mr. B. Sinha submits that the learned counsel submits that there are certain typographical errors in the translations so carried out in respect to various documents. He therefore submits that he may be permitted to withdraw the instant writ petition and file a fresh one by making the necessary corrections. So taking into account the above, this writ petition stands closed on withdrawal. However, liberty is given to the petitioner to refile after removing those defects. 9.
May please, your lordship. Miller, inaction on the part of the IRDA, Miller, for not initiating proceeding for cancellation of license, Miller, of respond number 1, is the subject matter of the petition, Miller. Fact of the case is, Miller, I suffered road traffic accident, Miller, and suffered injury. Before the MSc case, Miller, I was awarded compensation. Page 19 is the judgment, Miller. It is page 19. The delivered, Miller, on 2/4/2024, Miller. Now, 2015, Miller, an amendment was brought in the Insurance Act, Miller, wherein it was stipulated that if a judgment remain unpaid for 3 months, Miller, the IRDA may initiate a proceeding for cancellation. That is, lordship will find it page 60, Miller. Plus 4, Miller, sub plus 4, page 60, lordship.
What has happened?
The insurance company has not paid the awarded amount, Miller, and the IRDA has not initiated any proceeding against them, which was by law mandated, Miller. Agreed, we have.
Who is respond number 3?
Respond number 3, Miller, is the honor driver, Miller.
Who is to pay?
The insurance company, 1, Miller.
Where is the award?
Award is, Miller, from page 19, award is page 30 lakh something was granted. That is, lots will find it page number.
Why the original award is not here? Certified copy?
Sir, this is the computer generated copy, Miller.
What?
Computer generated copy, lordship. That we can take the printout like in the High Court itself, Miller.
I don't understand why we have not produced a computer generated copy has a digital signature. Where is the digital signature here?
Lordship sees page number 19, Milord.
Huh?
If Lordship takes a page 19, Milord.
Okay.
There's a QR code, Milord. Same authenticity, Milord.
So there was a direction to pay when?
Pay within 2 months, Milord.
Then why you're not going there?
Then, Milord.
Before the before the MSCT?
The MSCT one is, the process is very lengthy. Second, Milord, there are hundreds of cases like this, Milord, where the insurance company, after the judgment, has not paid the sum, Milord.
So what? Why would this court become the executing court?
It's not the executing court. I am only praying, Milord, that the IRDA should initiate an appropriate proceeding so that claimant may get their appropriate relief, Milord, in fixed time, Milord.
Let's see what is the power.
Page 60, Milord.
Page?
Page 60, Milord. This is 2015 amendment. It starts from page number 57, Milord. The relevant page is page 60, Milord.
Page?
60, Milord.
Where?
Plus 4, plus 4 lots may has, Milord. 4th paragraph. The authority may suspend or cancel the registration of an insurance either wholly or insofar as it relates to a particular class of insurance business, as the case may be. Now, subclause E. If the authority has reason to believe that any claim upon the insurer arising in India under any policy of insurance remains unpaid for 3 months after final judgment in regular court of law.
And
Now,
when did you approach the authority?
that's it.
When did you approach the authority?
Milord, we have not, Milord. It is their duty. We have not approached the authority, Milord. It is their duty to, Milord, initiate a proceeding. And
How will the authority know? You are asking for amendments.
Milord, when a law has been enacted,
So what? How will the authority know?
that is the question, Milord. The authorities should have to keep a tag, Milord. Why was this amendment brought in otherwise? The purpose of bringing this amendment become infructuous, Milord. If the authority does not have a,
No.
and in
Nothing.
similar case, Milord, notice was issued, Milord, also by the Guwahati High Court, Milord.
Where?
Similar case notice was issued, Milord, page 99, Milord, 98 and 99, Milord. Page 98, Milord.
Then what happened?
98, Milord.
What happened?
In a similar situation, Milord.
What happened in this case?
pending, my lord.
So?
They have filed an appeal, my lord.
So what?
That's why it says remain pending, my lord.
Who has filed appeal?
The insurance company here in, my lord.
Regarding?
Regarding, they've challenged the quantum, my lord.
Then
Unless that appeal, MSC appeal is disposed of.
this court is not going to issue a writ in the nature of mandamus upon IRDA unless you have approached the IRDA.
There are two aspects, my lord. One is lordship, the second order is. my
Okay,
lord,
let me dismiss it.
lordship, one more prayer, my lord. The Supreme Court has also issued a suo motu writ petition, my lord. In that case, the factum was, my lord, that 200, around 200 crores, 2000 crores, my lord, was lying pending before the MSCT courts, my lord.
Mm.
Now, matter is more or less similar, my lord. Here, what happened, the insurance company, thousands of cases, my lord, has not paid the compensation, my lord.
This court is not going to. You come up after moving that IRDA, giving them 3 months, and thereafter you move. That's a different thing. But otherwise, no. I hope. Heard Mr. A. Lal, learned counsel appearing on behalf of the petitioner. The instant writ petition has been filed by the petitioner. Taking a direction upon the respondent number 2, that is the Insurance Regulatory and Development Authority of India, to comply in terms with Section 3 of the Insurance Law Amendment Act 2015, along with a further direction to the respondent number 2 to initiate proceedings against the respondent number 1, that is the Oriental Insurance Company Limited, for non-compliance of the award dated 2nd of April 2024, passed in MAC case number 1413/2020. In addition to that, the petitioner have also sought for direction upon the insurance companies to pay the awarded amount to the claimants in compliance to Section 168(3) of the Motor Vehicles Act 1988. This court, the learned counsel appearing on behalf of the petitioner has drawn the attention of this court to the Insurance Law Amendment Act 2015, and more particularly to Section 3 4 E, whereby if the authority has reasons to believe that any claim under the insurer upon the insurer arising in India under any policy of the insurance remains unpaid for 3 months after final judgment in regular court, the authority may suspend or cancel the registration of an insurer. This court had put a specific query upon the learned counsel appearing on behalf of the respondent petitioner as to whether the petitioner had at all approached the respondent number 2, to which the learned counsel submits with all fairness that the petitioner have not approached the respondent number 2. Under such circumstances, this court is not inclined to issue a writ in the nature of mandamus, taking into account that it is a well-settled principle of law that a writ of mandamus can only be issued when the justice have been demanded, which have been refused or denied. In addition to that, this court is of the opinion that the instant writ petition is personal to the petitioner, and it is not a public interest litigation. And as such, question of directing the insurance companies to pay the awarded amount to the claimants in compliance with section 168(3) of the Motor Vehicles Act 1988 would not be proper exercise of jurisdiction. Accordingly, this court finds no merit in the instant writ petitions, such the same stands dismissed.
Lord, with liberty to approach it, IDM, Lord, we dispose
That
of.
you should have asked previously. The dismissal of the writ petition, however, shall not preclude the petitioner to approach the appropriate authorities, including the Motor Accidents Claims Tribunal,
No, my
for-
lord, the IRDA, my lord, we'll approach the IRDA for
including the Motor Accidents Claims Tribunal, wherein the award dated 2/4/2024 was passed.
Item 10.
Yes,
The petitioner is seeking some information from the state public information officer, food and civil supply of Dhamaji district, my lord. The RTO application is at page 14.
page
14 is a translated copy, then page 15 is the original copy. Regarding supply and distribution of EDS item. at the-
what is the reply?
Then, my lord, the concerned officer has directed the concerned agency to supply the information. As nothing had happened,
Then what
ultimately,
happened?
I approached the State Information Commission, page 18. On 3/2/2024, clause 5, directed the concerned SPIU furnish the information, the petition wise. And thereafter, I submitted the copy for the SPIU, page 20. Page 26, the State Information Commission directed the SPIU to furnish the information. But till today, I have not received the information.
Then
Proprietor has submitted the information, but the next one, Messrs. Dhamaji RF Mill has not submitted.
then
My limited grievance, my lord, direct to your lordship may consider my application to direct the authorities. Submit the information, my lord. Information is supplied to me, my lord, then I will know exact supply and utilization of PDS item, my lord. The district of Dhamaji through Messrs. Dhamaji RF Mill.
now kindly come to page 23.
Yes.
What is this document?
My lord, in respect of the information related to allotment copy of the what so and so from the year 18 to 22, but I am claiming for 11 to 2022.
The allotment copy from 2011 to 17 could not be traced out. Is not possible to furnish the same from our end. The remaining required information will be furnished by the concerned as the information is available with them. Then
Concerned proprietor of Messrs. Dhamaji RF Mill is
what
required.
is your basis of asking from 2011 to 17?
The petitioner came to know that some irregularities were going on, my lord, therefore he has.
But
submitted.
there is no, you cannot ask them if the authority does not have what information can be given.
Well, the
Whom should
information,
we direct?
my lord, information may be available with the concerned mill, my lord, not with the office. And therefore,
Concerned?
mill, Messrs. Brahmaputra.
Concerned meal, how can this court issue a direction to them to give? They may not give.
For the SPIU, my lord, State Public Information.
If the SPIO can, if they have those records, they can give. Otherwise, how can they give?
My lord, page 27. this
You
is the-
show me that they have records of 2011 to 17. Show me. Can you show me?
Yeah, no.
Not anyhow, can you show me that they have the information from 11 to 17, or they are required to maintain those records? Show me that. If you can't, you don't have a case. Isn't that, Mr. Borua?
Yes.
Because this court cannot direct the mill
Private.
concerned that kindly give him the information. That is not the part of this court.
Page 27, clause 4.
Huh?
27,
No, that is the action taken report.
report from 1 to 3, what they have taken, my lord. And page
27.
4, on receipt of the order passed by the commission, the undersigned had again instructed the proprietor of Demaji RF Mill to comply with the commission's order and furnish the required information within 3 days. By letter so and so, a letter of the appeal. The appellant is also prepared to find.
No, Mr. Counsel, I understand, but under the Right to Information Act, can the authority direct somebody, a private person, to get the information? No. Can it? That is not the purview of the right to. You have a right to get
Public-
information against, even against third parties, if it is in the possession of the respondent, of the authority. If the authority does not have the, what business does it have?
The concerned mill is under the control and authority of the SPIU, my lord. They have to procure.
Mr. Counsel, only tell me what information you have not got is regarding the allotment orders from 2011 to 17. The authority says that they don't have it in their possession. Now the question is, if they don't have it, you are therefore to show me that they should have it.
Maintain.
And as such, in fact, they are wrong in saying that they don't have it.
Let it come next week, my lord. I'll satisfy, my lord.
Learned counsel appearing on behalf of the petitioner 2 weeks' time for further instructions in the matter, list the matter again on 11th of September 2024.
Item 11.
None appears on behalf of the petitioner on call. List the matter of 2 weeks.
Lordship, repetition is also not maintainable, Lordship. Repetition is also not maintainable, Lordship. Under section 16(3), Lordship. Indian Telegraph Act, Lordship, we have to approach, Lordship, district judge.
Understood, if he has not appeared, I can't help it.
Supplementary item 53.
Appellate, Lordship. Additional affidavit has been filed, Lordship.
Yes, what is this?
One additional affidavit has been filed. Not verified.
Who is the department?
PHE.
Huh?
HE department.
PHE, no counsel. No counsel. You wait for some time. Huh? Get the moment we get hold of our PHC council, will hold it. So these people will appear. Either Mr. I. Bottakor or D. Gogoi or P. Pathak, all these things. Once they appear, we will pass orders.
For admission, item 12.
My lord.
What happened?
But no update as of now from the department to us. We have not received any intimation.
Mr. Gogoi, what?
Well, so far as my instruction is concerned, my lord. Pursuant to the proposal submitted by the DME, the government has now, my lord, sought for some approval from the Honorable Chief Minister. So it is lying in the office. I pray for further some time, my lord, to make it available. Because it's involves a huge amount that approval will be necessary. Then it will be routed to the finance and it will be done. And additionally, they have sought for some opinion from the Advocate General too. All these things will be, my lord, done within a short time, my lord. I have conveyed, my lord, whatever was.
As of now, he has taken over the land by issuance of that notification.
Yes, and I had a talk sometime before with the concerned additional district commissioner, land acquisition branch. He said that, my lord, nowadays, my lord, since these acquisition proceedings are drawn under 64 Act, and then, my lord, compensation is of course, my lord, determined under the 2013 Act. Now, therefore, my lord, if the award is passed, my lord, and if the money is not deposited, that will create problem. But nonetheless,
Why?
because award will be passed, my lord, but and money will not be credited. Because he will
Understood.
have to communicate.
Don't you think that the award being passed, then the interest will be only 9%?
9%. That is what, my lord, I have communicated to him. He says, my lord, that within this week, my lord, they are going to pass the award. I have conveyed in, my lord, in clear terms. Within this week, my lord, the formal award will be passed. Then, my lord, so far as the quantum is concerned, my lord, they will take a call, my lord. Things will
Because
be
then
sorted
the
out,
award, the moment it is passed,
my lord.
then the interest will come down to 9.
9%. That's what. That's what. Because here is now that conflict of that, my lord, 12% and 9%.
Huh?
Conflict of interest with regard to 12% and 9%.
As of now, it is going on 12.
12. Therefore, he will do it, my lord. I have conveyed, I have duly instructed him. Just, my lord, 15 minutes
Now,
ago, I
therefore,
had a call.
if the award is being passed
My lord.
and they don't have the money, it would be taking away the land of the
para 13.
Yes.
Para 13, the petitioner beg to state, publication say note in newspaper should not be just formality. Publication should be made so that people in general knows about a tender process, more and more interest per person can participate in the said process. But the instant case, tender notice stated published in newspaper circulated within Kokrajhar area, and that too in Kokrajhar base Boro medium paper, and only about 1% to Assam who knows and understands the said language, a resident of said area.
It is in Boro
As such-
language.
Yes.
It is published in Boro language.
As such, my lord,
Is
we
it,
kindly-
is it only limited to
Yes,
Boro
Boro.
people?
Yes,
No, no,
yes.
is the tender only limited to Boro people?
That's- Yes, that's.
Because it is not given in the local language.
My lord, kindly see your que-
Where is the newspaper?
Boro language is the local language in the Kokrajhar district. Boro language is the local language in the Kokrajhar district.
No, 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 no. There you can't have it in the Boro language because here the act does not say it to be in the Boro language.
No, but your lordship's query has been met out. As such, the tender is not widely circulated in the instant on the ground alone is so a sustainable liability to be set aside and questioned.
Where is your newspaper and your newspaper, most of you? And his newspaper will be more helpful, not yours. Because here in your newspaper there is no
No,
circulation.
no, I do not.
But it is in English.
Huh?
It is
No, no. Why will why are you publishing? It doesn't say in the vernacular. It is in Hindi or Boro. The Boro newspaper.
It is not, it is in written as English.
This is in Boro language.
Hindi like
It is Hindi. But
The script is Hindi, but it is Boro language.
But the advertisement is in English.
No, no, that hardly matters. Why will a person look into that? Hindi. Huh? Good. Advertisement, why will a person look into that? When it is not mentioned in one daily newspaper having circulation in that area. Why have you put it in Boro? Why Boro? Is this tender restricted to Boro people? I'm asking.
That cannot be, madam.
If it is not, then why have you put it to Boro? A person may not take a Boro language. Why you are not putting it in Hindi or English or Assamese?
Basically, this paper is from the Kokrajhar area, my lord.
The Kokrajhar area doesn't have
Kokrajhar
any.
area And in fact.
You need only circulation in that local area.
Local area, my lord. If
What is required is having circulation in that area.
local area, my lord.
There is no, local is missing. Having circulation in the area means where you are publishing, there should be circulation. A newspaper, a daily newspaper. But it does not say, but if you are not restricting those persons to Boro people only,
Not poor people,
Then-
maybe because as per the act, my lord, it had to be in the local area and as well as the persons who are also appear.
Yeah,
in the
Boro.
expedition, they are also more. Out of 4, 3 are Boros.
Boro people.
3 are Boros.
I am also Boro.
Huh?
I am also Boro. I am also Boro. They are
They
also-
know the language, my lord. That cannot be in, lots will see in the Assam Tribune also some Assamese ads are given, Assamese tenders are, in the Assamese language also tenders are given. That doesn't restrict much.
No, it's okay because Assamese is an official language.
Lots.
Assamese is an official language. It is even a language of as per the constitution also. So it can be very well given. And English is always there.
I'm saying
But
that in
if
the
you are
Assam-
restricting to Boro, unless he shows any prejudice, because he can't show 1, 2, and 3 are Boro
Boro
people.
people, that's my reply also. And they are from that particular area, and that brethren are given from the paper of that particular area itself. Because the Act says it should be in from a local area.
So then the question would be whether petitioner has prejudice.
No, today your lordship is in a bigger issue. Because your lordship is not, my lordship
Yeah,
is,
bigger issue has been small down, has been reduced.
by small down by saying that they are not applying. But today your lordship is taking into account of 34.2. 34.2. Once for it will be settled, whether it is a borough, I belong to borough, or my learned friends client being to borough. With a larger issue, today also on the face of it, it has been published in a borough language. What will be effect of 34.2 then? 34.2, my lord, I'll take your lordship one issue, my lord, here. Last time also I have taken into that. And your lordship pointed out, it is only in respect of PWD, Assam Financial Rules, that I have shown. Now that also it's clearly it states 254. Once your lordship will look into it, maybe in case of PWD, but that analogy can be drawn here also.
Regarding?
Regarding about publication of widely published, how it has to be published in one English.
Understood, but
vernacular.
that is a financial rules. Here is also a statutory rule. It
But
doesn't say, the financial
But-
rules cannot
but-
override here.
No, that's to my, the statutory rules also, we are on published in one daily newspaper. One daily newspaper, it doesn't speaks of borrow or non-borrow. It's one daily newspaper, it should be accessible to all. My lord, maybe your lordship said how you are prejudiced to it, whether you belong to a borough, he belongs to
No,
borough.
for
so
that you have to bring before this court the quantifiable data. Look here, this is a newspaper which is not published, circulated, whereas there are other newspapers of these types which are more circulated. There's a particular term use. It's like in the television you have the TRP. There is a term use. I forgot that name. What is that, Mr. Bora? You are expert in all this. No, there is a term used, like this term is there is always a fight with the big newspapers, the Times of India, Hindustan Times. They come up with this, and this is being published by a non-government entity. This is, and on the basis of that, they get advertisements.
Like the TRP of the TV.
It's like a TRP of the TV, but there is a term use. You have to bring those, that this is what is the circulation of these, which is not there. This there are no circulation and they have done it to the effect. But there is no data for that.
No, but this is the interpretation 34.2. I thought that will, because now that will not help. That procurement. Now I have to convince by bringing the data, because I just want my lord, that's subject to what your 34.2. Now lordship will kindly interpret, which may go against me or against them. I'll bring the data also to justify.
I understood. Your submission is to that effect that when there is a requirement of a notice published in a newspaper, it should be a newspaper in that area. It should be a newspaper which is widely circulated in that area. Else, the very purpose of making the publication becomes useless. That's your submission. But for that, don't you think that you are to show that this particular paper is not widely circulated, which is a more widely circulated? Some quantifiable, unless you bring that, how do I decide that?
Right. That's your lordship is right. Absolutely correct.
And if I'm allowing you yes, you can very well file an additional affidavit to that aspect of the matter, but it will be only improving it.
Some data has been given here. I think your lordship is right, the data has to be brought. What is the percentage of that area and what is the circulation? My lord, only data which I have brought at page 14, para 9 kindly be seen, my lord. Para 9.
See para 9, my lord. Your lordship got it? Para 9 of my petition. Para 9. That a petitioner begs to state the said newspaper Boroso is purely a local newspaper circulated only in Kokraj district and that too in Boro language. The main language taught in state of Assam is Assamese and almost all people who reside in Assam are known and understand the Assam. On the other hand, only about 5% people in Assamese knows and understand Boro language. Apart from that, the instant tender notice stated to be published in a newspaper of Boro language circulated in Kokraj area. Maximum 1% people who knows and understand Boro language are resided in Kokraj area. As such, by publishing the tender notice only in Kokrajhar based newspaper of Boro language, thereby deprived 99% people from participating open tender process. Tender was also not uploaded in the website of the Forest Department any authority. Paper cutting supplied is not tally with the original paper and such tender is not widely served as required under the law. I'll bring the facts and figures, my lord, to the court by filing an additional affidavit.
No, where have you stated you don't know to read Boro?
I'm sorry.
Where have you stated you don't know to read Boro?
My reply will make it clear, my lord.
Huh?
That is my reply to that paragraph, my lord.
What is your reply?
Paragraph 9, my lord, sunny page number 68. I read it, my lord. As regard to the statement made in paragraph 9 of the petition, the answer deponent begs to state that the contention of the are self-contradictory and self-defeating. All the persons are resident of Kokrajhar and 3 out of 4 petitioners are probably from Boro community. As such, the contention of the paragraph does not hold ground. my lord.
Because you are to
But
say that you don't understand.
Now this question, the larger issue will be, now if that paper, there is no paper publication, we are saying. They have given 2 papers, which is not published. That's the whole issue, my lord.
Yes, this is ABC of yeah, compiled circulation figures. Yes, this is it. Audit Bureau of Circulation. I told you, na?
How
If
much is-
it's a company.
Non-governmental.
No,
Audit Bureau of Circulation is the authority which does it. I mean, it's a private entity who does it. And they give this, there is a particular term used. What is the, it's called? There you can very well find out which language, how much is the, just for example, if you put Boro, which is the most published newspaper. If you have only filed for the response number 4, petition number 4, you could have made out a case. But doing all together to afford you must have been the reason.
No. My lord, now if today your lordship examine and find that this particular newspaper has not been published, what we are saying that now the
How do I find out? Tell me. One has, give me a good idea.
not been published.
When they are, more particularly that person, the newspaper publication company has also stated that they have done it.
But we got a newspaper which has not been done it.
Hmm?
This is the same newspaper. We have the same newspaper.
My lord, apart from that, my lord,
Hmm.
in this respect, in regarding settlement of this Mohol, in 2021, another tender notice has been issued.
How many people participated in this tender?
Yes, they had already participated in earlier tender. It was that, but settlement has been allowed to me. But since there is some miscalculation of the authority, it is mentioned of 2 crores 7 lakhs per year. Actually, it is for 7 years. That is why we could not take the shelter, and we are not also getting the mining clearance. That is why our tender has been cancelled. Similarly, on the basis of state tender, they also apply. All of them apply. Their tender has been rejected. Then question of e-filing, another circulation, not arise. Now, very same tender Mohol, my lord. Now there is these questions that
paper, there is no paper.
Earlier publication was in this newspaper only.
Paper is not there. Earlier also I don't know,
How did you participate?
they're similar, sir, but no action.
Which newspaper? You do one thing, you bring the records.
Yes, that is.
Then, my lord,
Then you have to be, with the record earlier,
Earlier, where he was being granted and the present one.
present I have it, my lord. But
You have
earlier,
it? How many persons have participated?
6%, total three on the one petition and 3 on other petition.
Huh?
6% total. 3% for the Falaknama and 3% for Falakata and the 3% for
There is two mahals where
Two mahals.
participation. One,
And
hall,
both are same.
Dalabi.
same.
Both are the same persons.
Same.
And how much was the participation in the earlier one,
Well, I have to go to
where the petitioners were there?
that I have to go to them. That I have to go to the record and all these things. And they, if they have the
6%.
petition, then
earlier, my lord,
Page 34, I have stated.
yes, madam, they
34,
they
there
have,
was 12%, 34,
yes, they have an comparative system. They have that.
34. 34, 12%. 49 again. 34,
Comparative statement is there. Yes.
There are 12%.
12%, earlier 12% participated.
And what was the newspaper which was published there?
that's why I'm not aware my learned. Yes,
Comparative statement is at 12%.
My lord they can produce a record of earlier 2021. And
Who
see,
is paying for respond number 11?
paper.
Paper,
Who is he? There was somebody who was appearing.
M. Bhattacharjee.
And what is the in similar nature, and on the basis of earlier tender, they also get some allotment, settlement. They also did not take, their tender also cancelled. I got on record for this particulars in my additional everything. They also participated and other mall also, and those are allotted to them. But they refused to accept, and evidently their tender also cancelled. They didn't tender also cancelled, the repetition. I brought on record in this matter also. Now in the present case, my lord, now first time they had raised a question about tender notice, for the first time. Earlier, they are not raised any such question.
No, e-tender is gone. No question, e-tender. But how do they read 34.2 is another thing.
but that is one aspect of the matter. Another aspect which my learned friend has said, it is for a period of 7 years, the amount which they have given. But by the virtue of this rule, it is says something else. It is annually. I got 2 crores, it is annual. Kindly see the word of 18.2. The no bid shall be 18.2. See my lord kindly 18.2. Page 257. 257. No bid shall be regarded as success unless accepted by the competent authority. Amount of the success bidder bid shall become the annual contract money payable by the contractors. The annual contract money determined at the time of initial grant shall be increased at the rate of 25% on completion each block of 3 years. So how can they say the entire is for a period of 7 years? Annual, I quote a rate.
But that is for the earlier period, not this period.
No, earlier.
Earlier is gone. We are nothing to do.
Earlier
No,
also-
earlier I was only looking into one aspect to the matter.
Earlier also, my
If
lord,
there is the publication has been rightly done, I have nothing to say on that.
earlier also they
No,
acquired
question.
2 crore 50
Because
lakhs.
at the behest of a tenderer person who has not participated in the bid, unless you show that it is the case of where there was no publication at all, why should this court at all entertain?
He said, my lord.
Your only point is on that wide circulation. But for that wide circulation, you need to have the data, which is, madam, you are appearing. Not, no problem. Okay, you are appearing for response number 11. Now, what do you do with these newspapers? You give it to various libraries, I suppose. These newspapers. You see, whenever you print newspaper, these are all kept for archives. It has to be kept. Every newspaper is kept for archives. If you go by the RNI Act, Register of Newspapers and AR, there is a mandate by which you are to keep those newspapers. Every copy of the newspapers are to be kept in a particular manner. Because that is the only issue. There is no other issue. Need to finish up this. Too much of time has gone. There's an act called the Register of Newspapers, Register of Papers Act or something, I forgot. This act. PRB Act. Press and Registration of Books Act 1867. This is the act. This is the manner in which you are to keep your newspapers. Everything is. The registration area means any registered so and so. Press and registration. Panasonic. 1954. This one. Kindly see. You see this act. Delivery of Books and Newspapers, Public Libraries Act 1954. Here it says that subject to any rule that may be made under, but without prejudice to hear, the publisher of every book published in the territory to which the act extends after the commencement and notwithstanding any agreement to the contrary, deliver at its own expense a book of so and so, delivered to the National Library so and so. Subject to the rules made, the publisher of every newspaper published in the territories to which the act extends shall deliver at his own expense one copy of each issue of such as soon as it is published to each such public as may be notified in this behalf by the central government in the official gazette. You see, in terms of section 3A
Yes, I know that, yeah.
of this act, because they have to, that is the document which will be the most authentic document. That is why for maintaining of archives, this is being done. You have to keep this. Whenever there is a publication of a notice, how many copies they may make, it's on. But the actual newspaper has to be given to that public library.
But that whether public library, whether this has been given to them, that particular, that will be there, kept there.
In the territory of India, whichever is the public library, central government has notified, there will be a notification by the central government which are the public. Boroland area may have it. If not, it will be the district library. Somewhere every district has a library. So therefore, that would be the public library which is normally given, if I'm not wrong, because I was doing some other matter, then I remembered. So then in that case, this is a year we can very well direct them to produce that. That will be the close the matter, whichever it is true. Isn't it? Why should I go anything more?
But one more,
But that particular original paper will go to the district library.
Huh?
That original printed.
Has to go. Because otherwise it is penalty is there. So that will go. That is why I remember, because there is a requirement of filing. Then you will find. If it is a case they have made out a false case, we make 340. If they have made a case, we make 340. 340 provision and ask trouble the chief judicial magistrate of the concerned district to initiate action.
that complaint is, that's a procedure. Will as Lordship has to send to the complainant before the CGM. But this larger issue, my lord.
Larger issue, no, I have limited the issue very much now.
No, that's.
Because once it is, no, I would have understood if you have only taken up the brief for 4, petition number 4. Otherwise, it would not be, and when you have not made a statement that you are a Boro who doesn't know how to read Boro.
But that's different, my lord.
So
That will be, my lord.
out of 4, 3 are Boros.
Eh?
Out of 4, 3 are Boros. The respondent.
No,
is also
therefore, if he was only holding the brief for the petition number 4,
That's it.
problem was that all the petitioners had to join together to make this petition. Upon hearing the learned counsel, stop. This court, by an order dated 18/7/2024, had sought for instructions from the finance department of the government of Assam as to whether the Assam Public Procurement Act 2017, which makes it mandatory for going for e-procurement to an e-marketplace, would be applicable in respect to the dispute involved in the instant proceedings, taking into account in respect to the tender, which is the subject matter of the instant proceedings, taking into account and further whether proceedings, which in turn would aid in interpreting Rule 34 of the Assam Minor Mineral Concession Rules 2013. Mr. Arbo Pujari, learned counsel, submitted that due to a communication gap, it was not the petition, he could not prepare the affidavit. However, the instruction issued by the Undersecretary to the Government of Assam Finance (ECI) Department dated 7/8/2024 was placed. In the said instruction, which is kept on record with the letter X, it is seen that the Assam Procurement Act, Assam Public Procurement Act 2017, its rules and various notification issued therein under would not apply to the auction of the tender in question, as does not amount to public procurement. Taking into account the said stand, it therefore transpires that e-procurement, e-tender would not e-auction would not only be the mode as regards Rule 34 of the rules of 2013. Be it as it may, a conjoint reading of sub-rule 1 and 2 of Rule 34 would show that while sub-rule 1 stipulates that a public notice of 21 days shall be published for inviting bids or conduct of open auction for grant of mineral leases, contracts, permits, as the case may be. It is also mandated that in addition to that public notice, in terms with sub-rule 1 of Rule 34, the gist of such notice along with the schedule for e-auction shall also be published in one daily newspaper having circulation in the area. The language of sub-rule 2 of the Rule 34 of the rules of 2013, after the amendment so carried out by notification dated 26/10/2018, though somewhat is unsatisfactory, taking into account sub-rule 2 of Rule 34 mentions only as regards e-auction post-amendment and competitive bids of the open auction, which was previously there, have been omitted. Be it as it may, this court is of the opinion that in view of Article 14 of the Constitution, And well-settled principles of law by settled principles of law in view of the various judicial pronouncements, which mandates a fair and a transparent procedure while distributing public largesse, state largesse. It is the opinion of this court that the publication of the notice inviting bids or conduct of open auctions for grant of mineral leases, contracts, permits, as the case may be, would also require publication cannot only be confined to e-auction, but has also to be extended to all types of inviting bids or conduct of open auctions. It is a well-settled principle of law that the court, while interpreting a provision, is required to interpret the provision in such a manner which not only harmonizes the said provision with the other provisions of the state statute, but also is constitutionally valid. Under such circumstances, this court is of the opinion that there is a requirement for publication of the notice, public notice of 21 days, publication of the public notice in respect to all inviting bids or conduct of open auction for grant of mineral leases, contracts, permits, irrespective of whether it is carried in terms as per e-auction or any other form. And this publication has to be carried out in one daily newspaper having circulation in the area. Having opined so, the next question which arises is as to whether the petitioner herein, as to whether the newspaper in question wherein it was published, the next question arises as regards a factual adjudication as to which of the newspaper the reliance have been placed by the petitioner or the respondents is the actual one. Inasmuch as it is the case of the petitioner that this very advertisement was not published in the newspaper, namely so and so. published by the respondent number 11 in its edition dated so and so. Whereas the respondents submits that it was duly published in page number 3 of the said edition of the newspaper. This court further finds it relevant to take note at this stage the provisions of the Delivery of Books and Newspaper Public Libraries Act 1954, which mandates that there is a requirement of delivery of every newspaper in terms with section 3A to each such public library. As may be notified in that behalf by the central government in the official gazette. Who appears for the DC? DC is not a party here. Mr. N. Goswami, the learned counsel appearing on behalf of the district administration, Kokrajhar. Huh? This is not a
No, in
party.
the state we made a party.
Huh?
State only made a party, not DC.
State through?
My lord, state through the commission.
Commissioner
secretary.
Huh?
Commissioner and
Commission
Forest
and
and
government of Assam.
Forest and environment laws.
Forest, no. Goswami. Mr. N. Goswami, who is the deputy commissioner, who is the standing counsel, who is the junior government advocate, is directed to obtain instructions from the from the district administration, Kokrajhar. As to whether through which the district administration Kokrajhar shall obtain. I'll just pass the remaining order. You just find out which are the central notified public libraries in Assam. I'm coming back at 2.
Yes.
Just find out that direction can be passed. With that, if it is done, matter is finished. You just give a call also, find out where it is being sent. She will know. Where is the other lady? Oh, you are there. You will know. Just find out.
Lordship, as per their version, that means as per number 11, it is, they are not sure whether it is given to district library, their lordship, but they gave it to the secretariat there, BTC secretariat, here in the assembly, then public relation office, director of public relation here, and also public relation office there in Kokrajhar.
Who is appearing for the director of public relations here? In the Mr. N. Goswami, Mr. N. Goswami, who is the junior government advocate, is requested present in the court is the counsel appearing on behalf of the respondent number 11 submitted that copies of the newspapers are provided to whom?
BTC secretariat there.
To the BTC secretariat, the
Assam Legislative Assembly. here.
Assam Legislative Assembly, the Director of Public Relations,
Yes, Lordship.
Government of Assam,
Yes, Government of Assam.
as well as the
Their lordship, I think, is director.
There is a directorate of library.
Directorate of Library BTC. Taking into account the above, this court had directs Mr. N. Goswami, the learned counsel, a junior government advocate who is present in the court, and request Mr. N. Goswami, the learned junior government advocate who is present in the court, to ask the director of public relations,
Yes, Lordship.
public relations of the government of Assam to verify as to whether in the newspaper, namely
Podosha.
Sanseyari Boro, Bodosa, Sanseyari Boro, Bodosa, of the edition of the 9th December 2023 edition, volume 33, issue number 23, 253. There is an advertisement at page number 3, issued by the Divisional Forest Officer, Parbot ARBATJHORA Division, Suparighat. The said information be provided to this court positively on the next date. List the matter again on 5th of September 2024 at the top of the list.
7th, my lord. 7th of the.
Huh?
7th, my lord.
7th is Saturday.
That will be not available, my lord. Put that, my lord.
Senior counsel, accommodation? No.
3rd, my lord. 3rd, my lord. 3rd.
Third, you get it. Third.
Please send me a copy of the.
I will submit.
Both of you submit. You see this newspaper advertisement? Give a photocopy.
Interim order will be continued.
The interim order passed earlier shall continue till the next date. It top of the list rakhichu de.
Deeply obliged.
Mr. Borbuzari, how can GMDA take over the land from the petitioner unless you make the necessary correction in the records?
Yes, therefore, my lord, there is a tripartite talk going on. I have received the instruction, Lordship may kindly
Very
bear
good.
with it. There's a tripartite talk going on between the representative of the petitioner, that is Jagadish Prasad Sharma, then my lord, the district commissioner and the CEO of GMDA.
Understood. But you need to correct it.
Yes. Now the difficulty is that, my lord, on site, my lord, on field, there are several encroachments. Now those encroachments have to be cleared up. If the market is to be shifted to North Guwahati, it has to be encroachment free, my lord. Now, they are challenging the ceiling acquisition process here. Now, my lord, the fact remains that, my lord, that 250 bighas of land, part and parcels of 250 bighas of land, so far as, my lord, falling under two mojas, my lord. With regard to one moja, my lord, we have filed an affidavit. Now, in the latest affidavit, my lord, some disputed question of facts has been, my lord, spelled out. Now, being situated in that state of affairs, well, now the
No, the
authorities-
problem which is going to happen is this. Unless the petitioner, unless this court decides in favor of the petitioner, as per the prayers so made, Can the this DMDA take over?
No, if the authorities, all the authorities recognize that it is their land, plot of part and parcels of land.
Not only that recognition, you are to change it. You have to change it and then only it can happen.
Absolutely, absolutely.
So you have to, either the change can happen on the basis of an order passed by this court, or you can do it by yourself admitting that there was a mistake committed by you. Now, if that be so, one problem is solved as regards the other DAG number, pata number, which was there, where it has been wrongly given to them and there has been an auction sale. All these things are duly taken care of. But if you don't do it, the GMDA cannot be given because that will again lead to another problems.
Definitely, because the title will have to flow to them. In absence of any title, which is now clouded, of course, it is their allegation.
Now, can you correct the 7 statements, section 7 statement?
Yes, that is one question, yes. As of
Unless this court passes an
Yes.
order.
now, so under that situation, if Lordship may be pleased to keep this matter pending for some time and wait for, my lord, the outcome of the meeting, then Lordship may adjudicate it, my lord. At least one,
Because to do it,
yes,
you need an adjudication that you have wrongly done, and this court has to give a declaration that you have to give it to them.
absolutely.
And on the basis of that, you do it and then proceed as per your tripartite. That would be, I think, the most conducive way.
Absolutely.
And there would be also the backing and the stamping of the authority of this court. Otherwise, there will be a lot of problems.
Because
Just for
GMDA
example, there are people who are otherwise encroached.
Yes. Encroachments are there, yes, yes.
How do you take care of them unless you put it to him? Then it would be a private dispute between him and them.
Yes.
The moment you do it, you have to take it by way of some form of a consent acquisition.
Yes.
Consent acquisition you have to do. Once you take that consent acquisition, then the property based upon you, by which you can take care of those encroachments.
Absolutely.
Something has to be done in that manner, the plan. It cannot be on the basis of you three entering into an agreement. Nothing is going to happen. At the end of the day, if you give him the money, he will be satisfied. Mr. Deka will be very happy and will go away. Problem would be faced by them.
Here I will interfere, my lord. My instruction is that money will not flow to the petitioner.
Huh?
Money will not be given to the petitioner. Now the instruction is that money will go to. There will be a tripartite meeting, my lord. Thereafter, the records will be corrected, the title will be given to him, and then the GMDA will step in and build a structure, and he will not get any money. He will get the profit share of that particular construction till that agreement will come on the building. He will only get the profit sharing of that particular building. This building will be rented out to the wholesalers, that particular, then the meeting will be there, that at certain.
So you will be taking it on long-term lease.
There is a process going on, but they will get only the profit, not for transferring the land.
No,
they
there will be it will be a case of long-term lease.
that will maybe that in future.
If you
that
are
will be
building on his property, has to be on the basis of some right. The some right has to either flow from the sale or by a lease.
The transfer has to be done. Then in the meantime, everything has to be the
Or for
construction
that
of-
purpose, he may enter into a development, some form of an agreement by which
whether
he would be allowing you to construct and of which the profit sharing will be there.
profit sharing with them.
That is another aspect of the matter.
First the
But then
process-
also, this has to be first decided.
Because now
In
it's a-
order to enter into that also, don't you think that this court needs to pass that order?
So as on date, it is a Sarkari land. We can easily take over. That cannot be managed now. The process is on. Now that particular land have to be transferred. Revenue department, DC have to transfer in the name of the petitioner. Then the process will start. In the meantime, that agreement had to be there.
There are two ways. One is that which you have a private treaty with them. That's another aspect of the matter. But the other aspect would be as regards acquisition.
Acquisition, purchase or lease, whatever it is.
A lease will be between him and him.
Therefore, once their title is fortified, it is for them, my lord, to whether they would like to enter into lease, whether they would like to sell off their land, whether they would like to part away with their land to the government authorities by means of acquiring. It is for them. This is where the matter stands. And in the latest affidavit, my lord, filed on behalf of the deputy commissioner, they have now raised some dispute regard to that, my lord, since these are old, my lord, records pertaining to the year 1976 onwards. Now, my lord, they say in the affidavit, say, my lord, that the plot of land, part and parcels of land, which were involved in, my lord, selling process, my lord, those are not these lands. These were some other lands. I have filed a short affidavit, my lord, that extent, on verification of the present records. So then lordship will have to adjudicate. Of course, taking my affidavit into consideration.
Lordship will post it after 2 weeks, but in the meantime, next
No,
week. there's a meeting.
this court is not going to go into all those aspects of the matter. The court is only going into the aspect as to whether, while doing the section 7 statement which have been done, whether it has been rightly given to him that 9 patta or the other patta was rightly given. That's all. If it is right or wrong, that's it. If it was given wrongly, the 9 patta, 13 patta, but it should have been given the 9 patta, madams, the statement which is made on the 7 will go. Now, the problem which I'm facing is the moment I set aside or can I partly touch the section 7 statement? If I cannot, the entire sealing proceedings will become useless.
It will, then again, Mala, they will have to again, Mala, redraw the proceedings.
Redraw the proceedings.
Redraw the proceedings.
The redrawing the proceedings will may have another effect.
Absolutely. Therefore, my lord, since we have traveled so much, my lord, to this extent, of course, in this matter, lordship may be pleased to accommodate us for some further time, my lord.
I'll accommodate you, no problem. But yeah,
Because
because I don't know. So.
It's the case of the petitioner. My learned colleague will, of course, not disagree with me, but they have approached the authorities. They want to find out a solution because they are unable to enjoy the possession.
Next week, one of the meeting is done. Private meeting.
It has been submitted at the bar.
Just one more aspect. We have submitted IM for implement. Here the annexure 2 of the writ petition shows there the Jamabandi, our names are there. Our names are also there. If the acquisition process is detected by this honorable court, or if it is again, my lord, that the re-acquisition, if it is taken, my lord, then we are the cultivators, my lord. We are still possessing the land. Now, I don't know that he has said that enclosures are there, but we are still in possession. We are the occupants, occupancy tenant. Earlier, we are occupancy tenant. Now we have our names have been entered in the Jamabandi also, man.
How?
Yes, and the 2 is there, man.
How?
Now, how after that, I think that is.
No, how? You have to say me how.
Yes, there is, I think, section 23 on ownership right. Of
No,
the
did you, were you his occupancy tenants?
Yes, my lord. Yes, we are tenants under him.
So then obviously, whatever is happening, it will happen, have an impact on that. We'll look into it later on. But as of now, if it is a case where he is entitled, here you have no business out here. Here is a case where if you are an occupancy tenant, you will remain as an occupancy tenant. We are not concerned with that aspect. We are concerned whether it has been rightly given 9, patta number 9 or 13. That's the issue.
Patta number 9.
So patta number 9, if he is given,
Figures, we are still there.
Mr. Sinha, your issue is not in stake out here because of the fact if it is the land which is being given to him, then also you will remain as an occupancy tenant of him. You have no other business out there. Did you file any application for ownership? You can very well file it. That is another aspect of the matter. As of now, you are an occupancy tenant, you remain it is. You may have a right if this land is made Sarkari, but what right do you have to question on the section
Sarkari,
7?
that is what the land has been made Sarkari, man. Only that the villagers did not know that it was acquisition. And they did not go.
There's no acquisition proceedings here. Where is the question of acquisition?
Already my lord, 76, my lord, 1976.
Arre, it is a case of let's say, land being taken on sealing.
Yes, my ceiling, man. Second ceiling. On
It's
ceiling.
not the question of
On ceiling,
acquisition.
land has been taken 250 bighas, my lord. In 250, we are there.
So
Still
very
we are
well.
there.
But your right does not change unless you go under section 23 or 25 seeking
I
occupancy.
think if we do not implement.
No, you have no business out here. Therefore,
When the-
that is why earlier also you made a submission I have not considered till now. We'll consider it later on. On the date on which we dismiss your petition, he's allow or do pass the order and dismiss your petition. Don't worry. Let the matter be listed again on 24th of September 2024 at the top of the list, taking into account the communication dated 21/8/2024 issued by the Additional District Commissioner Kamrup Amingao, wherein it has been mentioned that there is a certain negotiated settlement. There is a process for an out-of-court settlement.
Right.
Lordship may be pleased to keep this as a part of the record with all humility if Lordship chooses.
State
Kindly,
document
madam.
is made a part of the record and marked with the letter. This one give a A go do. A.
I move Lordship.
Yes, where is the PHE? Who have got hold of a PHE council? Wait. Your order I will pass only with the PHE council. Get hold of a PHE council. You keep on waiting. The moment you see mention it. Okay? What is this?
On the last occasion, my lord, some instructions were sought from the standing council of the BPC, my lord. My lord, our land was forcefully occupied by the Indian Army. By viewer before lordships.
Huh?
Our land was forcefully occupied by the Indian Army without any acquisition proceedings. That is why we came up by way of this petition. If my lord may come to the last order, 5th of August, my lord, second paragraph. The standing council submits that he would receive instructions as regard the assessment made with regard to the land of the petitioner possessed by the army authorities for setting up their counterinsurgency operations at Simla.
I appear on behalf of Mr. B. Chaudhary, madam. Yes, please for further 7 days time to have the inspection. madam.
Who is, why?
From BTC, madam.
No. First of all, who is occupying the land?
Now it has been vacated, my lord.
Vacated.
After filing the petition, they have vacated it. But from 2008 onwards, they had forcefully occupied the land.
And what is your prayer?
Some compensation, my lord.
Compensation from whom?
The army. my lord.
Where is it? Where is your prayer for compensation?
My lord, page 12, my lord, para B. Written the nature of mandamus or any other writ order should not be issued, commanding the respondent authorities to pay adequate compensation to the petitioner for forceful and illegal occupation of his private land measuring about 2 feet. After
Now, what do the army say?
my lord, they say that they have occupied the land on being shown by the district administrator. But they do not have any records to substantiate that.
Have you brought on record that it has been vacated?
No, my lord, this was after the writ petition, after the.
So why,
Now,
don't you
my-
think that now your would be the requisition cost in terms with similar parameters should be applied as per the Assam Land Requisition and Acquisition Act? Why you're not making something, some pleading to the effect?
And I'll obtain the exact instruction as on which.
And how much you are entitled to, then only we can put them to notice. As of now, nothing is going to happen. BTC has no business. What is he doing to do? Regards assessment made in regard to the land possessed by REA for setting up the area. What is the BTC going to do? Here the army has taken the land, they have forcefully occupied, and thereafter you are entitled to this compensation very well. But the yardstick can very well be brought in from the Assam Land and Requisition. Mr. P.D. Nayan, the learned counsel appearing on behalf of the petitioner, submits that in view of the vacation of the in view of the handing over of the possession of the lands in question. Army?
That wasn't.
In this case, I don't know, but some maybe, I can appear, but I'll take instruction.
That in view of the handing over of the possession of the land in question by the army authorities pursuant to filing of the instant writ petition, he would like to file an additional affidavit bringing on record the said aspect of the matter, and further give better particulars as to how much amount of compensation the petitioner, how much and better particulars as to the compensation to which the petitioner would be entitled to for the illegal occupation of the petitioner's land by the army authorities without following the due process. How much? List the matter again on 29/2024. The said additional affidavit be filed by 18th of September.
16.
There's a provision, Mr. Nair, wherein it says how it is to be calculated when it is done for requisition. You may also find the same in the Land Acquisition Act, but I think that this Assam Land Requisition and Acquisition gives a better one.
I'm deeply obliged.
Yes, what is this?
I'm paying for some time, my lord, because
You have filed the affidavit?
filed by the.
Well, do a file.
Need some time. At least 3 weeks time is required.
For what?
Give a counter.
No urgency? No urgency. The learned counsel appearing on behalf of the petitioner submits that in view of the affidavit filed by the respondent, number 4.
2 and 3.
Respondent number?
2 and 3.
2 and 3. The petitioner would like to file affidavit in reply. Full stop. List the matter on 1st of October 2024. In the meantime, affidavit be filed. Where is he? Yes, Mr. Botto. You see, this is a case of contempt. You may say that you have nothing to do. I'm not concerned on that. There is an order being passed on 9/4/2024. There is a direction for you to verify by the Chief Engineer PHE, verify the claim of the petitioner and proceed in accordance with law within a period of 1 month from the date of receipt. You give a copy. You just get your instruction within 1 month or now has it been verified. Just that, nothing more than that.
I'll take.
And if not, I'm fixing a date on 11th of September. Get it verified. Chalo. This court, taking into account the presence of Mr. I. Botakur, who is the standing counsel of the PHE department, has requested him to apprise this court as to whether the due verification has been done by the Chief Engineer PHE pursuant to the order dated 9/4/2024 in WPC number 2147/2022. The learned counsel, standing counsel submits that he would obtain necessary instructions in that regard. list the matter again on 11th of September 2024. The registry shall show the name of Mr. I. Bottakur in the house list. Get only that. Done, closed. Not done, then I issue notice.
Contain.
Well, as for the last order, I have take instruction, my lord, regarding the eviction cases, my lord. Actually, the state official, my lord, rejected the, dismissed the, my lord, all the eviction cases, 17, my lord. So 17 eviction cases have been dismissed by the state official for not production of the documents by the related authority. So this case become infrastructure, my lord, now, my lord. Eviction case, my lord, long begins 1/8/22, but case has not been listed so many days because of that, my lord. Dated 1/8/22, last page, my lord. Next page is the date, my lord.
Pursuant to the order dated 12/8/2024, passed by this court, passed by this court, Mr. K.K. Parasar, the learned standing counsel of the railways, had today placed on record a common order passed by the estate officer, NF Railway, dated 1/8/2022. The said order is kept on record and marked with the letter X. From the said order, it is seen that taking into account that the railway authorities have failed to produce that the lands in question wherein the petitioners are in occupation are railway lands falling within the definition of public premises in terms with the Public Premises Eviction of Unauthorized Occupants Act 1971. The said 17 cases, eviction cases, which were initiated were dismissed. In that view of the matter,
The challenges the notices, my lord.
in that view of the matter, the notices, in that view of the matter, the instant writ petition have become infructuous and accordingly stands closed.
But in case of standing council, railway, my lord, central government council, my lord.
Central Government Council
Like,
appearing for the railways.
Lordship. Lordship, my senior is out of station, Lordship, but we have received the instruction, Lordship.
Fantastic, tell me.
Last order directed to file the affidavit, my lord.
You have not submitted the no claim certificate?
I have verified.
That is why.
But final bill has already been paid in 2016, my lord. I have to verify.
It is seen that that pursuant to the order passed by this court dated 29/7/2024, the Standing Council, the Central Government Standing Council has placed before this court an instruction dated 18/9/2023. Full stop. A perusal of the said instruction shows that the petitioner have not been released the security deposit in view of non-submission of the unconditional and unequivocal no claim certificate. In addition to that, there is a mention that there is a audit objection to the final bill. Full stop. Taking into account the above, this court grants two weeks' time to the railway authorities to file their affidavit in opposition, failing which this court shall proceed with the disposal of the writ petition on the basis of the pleadings available on record. Full stop. List the matter again on 13th of September 2024.
Well, okay.
You get your information on that.
Yes,
as well.
yes.
That is why I incorporated it.
Yes, yes.
You're going to create your house. What is this case?
Case is relating to permission which was not given by the government in Prevention of Corruption Act for registration of FIR. Lordship, on an earlier occasion, on 24th of July 2023, when the matter comes before you, Lordship, an affidavit was filed by the government.
Bringing on record the order dated so-and-so whereby the competent has refused initiation of criminal case against the respondent number 6 through the Iman. And by communication has mentioned that after completion of the company, it appeared the respondent has possessed disappropriate assets amount to in comparison to his name. It was also mentioned that the inquiry officer has also submitted an inquiry report to suggest a criminal case against the respondent number 6 as per the provisions of so-and-so. However, reveals on the record that the service upon the respondent is not complete. The person is directed. Who is paying for 6?
It is not 6, it is 5 actually, Lordship.
Oh, then there was a correction made,
Yes,
no?
yes.
Who is paying for 5?
I may pay.
The 5.
Copy আছে রেকর্ডও আছে মানে আপনার প্রিডিংস আছে না
Now tell me why a sanction is required? Yes, Mr. Dinath. Because that was the question I put you on the last occasion.
Lord would recollect under 6A earlier of the DSP Act, it was required. Now, there was an interference with that order. Thereafter, section 17 capital A was inserted in the PCA. That is how it is required. The requirement emanates from 17A.
Oh.
Home দিয়া, পুরোনো কিতাব কোন দিছে?
No cross.
এটার মতো লাগিয়ে দিয়া। No police officer shall conduct any inquiry or investigation into any offence alleged to have been committed by public servant under this act, where the alleged offence is relatable to any recommendation made or decision taken by such public servant in the charge of his official function or duties without previous approval in case of a person who is or was employed at the time when the offence was alleged to have been committed. We are not concerned with A, in case of a person who is or was employed at the time when offence was alleged to have been committed in connection with the affairs of the state of that government. Provided that no such approval shall be necessary for cases involving arrest of a person on the spot on the charge of accepting or attempting or accepting to undue advantage for himself or any other person. So only exception carved out is, my lord, cases of where a person is caught red-handed. If your lordship should kindly come.
Now, why the government is refusing the approval? Run the sanction?
Well, the reason is given there, my lord.
Where?
In the order, 10th of June 23.
Page?
What is the page? Page number. My lord, the affidavit filed by page 48, my lord. Whereas on the basis of the proposal and the enclosed petition, Vigilance and Anti-Corruption Assam was accorded approval by letter dated 24/1/19 to initiate regular inquiry against Durlabh Somoa and submit report to this department. Whereas Vigilance and Anti-Corruption Assam had submitted the RE report by letter dated 13/1/21, wherein it was stated that SO Durlabh Somoa possessed disproportionate asset in comparison to his known source of income, and accordingly, Vigilance and Anti-Corruption Assam has sought for approval to initiate a criminal case against Durlabh Somoa. Whereas views of the Judicial Department and Legislative Department on the matters were sought, whereas Judicial Department right under order were of the view that in the instant matter, Durlabh Somoa being an ex-MLA in the light of the decision of the Honorable Supreme, actually Punjab and Haryana High Court, Surinder Kumar Bansal versus State of Assam, it is stated that prosecution sanction to prosecute him for offence under PC Act is not required. Whereas Legislative Department under white dated were of the view that prosecution sanction of Durlabh Somoa being an ex-MLA is not required to prosecute for an offence, as he has ceased to be a public servant on the date of taking cognizance of the alleged offence in the light of the order passed in Surinder Kumar Bansal and Shyam Bihari Tiwari.
Whereas in the meantime, WPC number Sri Hemanto Deuri and another the state of Assam, others filed in the Guwahati High Court and next hearing of the case is fixed on so and so. Whereas Vigilance and Anti-Corruption Assam was requested to re-examine the alleged misappropriation of government fund by Dulab Somo ex-MLA Nagaon and submit a report by later dated so and so. Whereas a re-examination of the alleged misappropriation of the government fund by the Dulab Somo was conducted by Vigilance and Anti-Corruption Assam through so and so officers of the VAC. Whereas it is stated in the report dated 25-23 that Dulab Somo was called for examination and the statement was recorded during the course of inquiry. The report also states it is found that Dulab Somo ex-MLA Nagaon was not president of the NGO, namely Best Friends Society Nagaon, during the period 2013 to 2014, while NGO received grant in aid under the AIDP scheme. Moreover, it is also found that he is not a signatory of any document regarding any receipt or utilization of fund by the said NGO during the aforesaid period. As per the available record, Dulab Somo ex-MLA Nagaon did not take part in the process of receipt and utilization of the fund received by the NGO, our Best Friend Society from the Ministry of Social Justice and Empowerment Government of India under ADIP scheme in the year 2013-14. Whereas the report concluded that the allegation of misappropriation of government fund by Dulab Somo ex-MLA Nagaon could not be substantiated as per the records collected during inquiry. After perusal of the report submitted by SP Vigilance, dated so and so on the allegation against Dulab Somo, the proposal submitted by SP Vigilance and Anti-Corruption for giving approval to initiate criminal case by later dated 13-1-21 against Dulab Somo is hereby denied by the competent authority. And in fact, if your lordship will kindly see the prayer in the writ petition, their prayer was only to grant approval. If the other side feels that this is not correct or something, then they should challenge this order, Milord. And in the prayer, if
You
your
have not
lordship,
challenged the 10-6 order.
No, lordship, after that, I have filed a detailed affidavit in reply. Yes,
Have you
lordship.
not challenged that?
Lordship, I have received an affidavit and I have challenged by way of an account.
No. Have you not challenged that order?
Let me complete, lordship,
No,
because I have.
no,
said-
Mr.
Because this order.
First and foremost, who are you?
The complainant, lordship,
You are the complainant.
Yes,
How are you affected?
I have filed a complaint. On the basis of this complaint, there
Where?
has been inquiry and there has been proceedings.
Where is your complaint?
My complaint is at page number 21 of the petition.
No. Then
Page number 21, lordship, 21 to 23.
how are you affected
Lordship,
by that person?
I have filed a complaint after seeing that the social welfare department scheme was come out in 2016. And since 2016, it is approximately 9 lakh childrens were forced in the system for getting reliefs from the social welfare departments. Actually, these students does not exist. And there is a massive scandal of around 2,250 crores. But what happened actually, the big kingpins, nobody has been touched. Only some small officers has been arrested and the entire scandal was covered up. Many persons who are known to me, they are doing all the searches and how this has to be put on. And accordingly, one person seek my help because he knows that I know Dr. Dulab Somo and what happened at that time, because I was working with a company. From that company's transaction with Dr. Somo, I have come to know him. And many people know him that I know him. So people touched me and said that what exactly happened in social welfare scam. Then I have explained him what exactly happened, but I don't want to come out in the open because there is a life risk, lordship. I have informed them that how money has been laundered, how money of the government scheme has been siphoned off to the ministers, officers, and in a percentage system, it has been distributed all over. And how properties has been purchased from all over Guwahati and the its places in Assam. In this process, many complaints, Fox complaints has been filed to the Vigilance and Anti-Corruption Department. Many of the complaints has not been considered, but somehow Dr. Samoa comes to know about that his properties, which he has purchased at the time when he was the MLA, that has been highlighted. And as he knows that at the time of purchase of the property, I am the person of that company, he sought my assistance that put your signatures on
Which
back.
company were you in?
It is Protect Realtors, Protect Buildcon Private Limited, Protect Realtors Private Limited. This is a Protect group. Lordship, everybody knows in Guwahati. So he sought my help that my some properties has been purchased, but my money receipt has been lost. All money has been paid to you. So you please issue backdated money receipts.
Who said?
Is the respondent number 5. I refuse, Lordship. Then after, how pressure has been built up upon me, my family, everybody is there. I have not banded out. Finally, when I am fed up, then I filed a complaint over email to the Director Vigilance and Anti-Corruption. Then Vigilance and Anti-Corruption Direct approached me back and clearly said that please meet my SP and put your signature on your official complaint. Then only I will take action on this. Lordship, please see, I have everything has been typed. I never wanted to be a complainant. But when I went to the SP, we have a 3.5 hour meeting with then SP Vigilance and Anti-Corruption, Mr. Anand Mishra. He elaborately told me everything, how myself, my interest will be harmed, how I will be harmed, how system works, everything has guided me properly. And then after I put my signature and I have decided to put this matter to a logical conclusion. How 2,250 crores rupees of government money has been looted and not even a single penny has been recovered. Now, what is happening in this matter? Lordship Glenn Senior Counsel submitted that section 17A. Respondent number 5 has filed 2 affidavits in this court. One on 26/6/2024, very recently, and one is on 15/9/2023. That is on the order of you, Lordship. In both the affidavits, there is no mention that this provision of seeking approval is under section 17A. They are writing it that the section 19 again and again in these 2 affidavits. But when the matter comes before this court, he start raising that this is section 17A. When Lordship, section 17A or section 19, it can only be said by the respondent number 4.
Mr. Petitioner in person, look here. Until you challenge, your case was that a grant of approval should be made. Now they rejected the approval. Okay. Listen, once the approval has been rejected, this court cannot touch without touching that. It would be very difficult for this court to decide. Why are you not filing another petition challenging that on whatever grounds? Once you challenge that, would be for this court, then it becomes easier for to take a look. Because why I'm saying it, your allegation to the Director Vigilance, although you are saying 2,150 crores or whatever may be, your allegation to the Director Vigilance is some 200 crores of that person. Why they have only mentioned about that Red Cross business?
Lordship, there are many affidavits in this court. Government has filed another affidavit on 25th of April 2024. At page number 169, Lordship, point number 3. So why? The stand of Judicial Department is at par with the order dated 10/6/2023. Page number 169.
Is the respondent number 5 anywhere office bearer today?
No.
Then how does it fit within the ambit of a public servant?
The allegation is with reference to.
Maybe, but the inquiry is only as regards a public servant only. Kindly see.
Yes, yes.
No officer shall conduct any inquiry or investigation into an offence alleged to have been committed by a public servant under this act, where the alleged offence is relatable to an recommendation made or decision taken by such public servant in discharge of his official duty or even with the Yes, but he has to be a public servant. Without
Yes.
being a public servant, how does this stay? Because from whom he will take the prosecution sanction?
No, my lord, if your lordship would kindly come to section 19.
Yes.
And you see, no court shall take cognizance of an offence punishable under so and so alleged to have been committed, except with the previous sanctions. Kindly come to A. In case of a person who is employed, or as the case may be was at the time of commission of the alleged offence, in connection affairs of the union. So my lord, is or was both. That is how section, the scheme of the act.
At the time of commission of the offence
Is or
employed in
was.
connection with the act is not removable from his office save by way of sanction of the central government of that state. And in the case by the state government.
Lord, my humble submission is, my lord, earlier to this, there was a writ petition, my lord. Kindly see the order in that case is at page number 94.
Hmm. 90?
Page number 94.
98. Oh, yes.
And the operative portion is at page number 96. Please come to the first subpara. It is further submitted that present is not a case of non-registration or lack of investigation, and police cases are being investigated, and respondent number 9 is ready and willing to cooperate. I was respondent number 9 with such investigation. This court has also noticed that in the additional affidavit filed by the petitioner, the communication dated 13/1/21, this is the letter, has been annexed by which sanction has been sought from the appropriate authority to initiate a criminal case against the respondent number 9 which is in connection with complaint laws with the vigilance cell. From the aforesaid development, it cannot be said that there has been inordinate or gross lapses or inaction on the part of the police authorities in investigation of the aforesaid 3 cases. And sanction being a mandatory requirement under so and so, the competent authority has already been approached for grant of such sanction. In view of above and also taking into consideration restraint.
Because this order was passed when you were a public servant.
No, it
This
was
was
not. No, it was not. This was passed on, Milord, 26/3/21. He was not.
He was not.
But the allegations are pertaining to the period when he was a public servant. Because
Understood.
in 20, Milord, when that original complaint before the vigilance was filed, that was an occurrence relatable to the period when respondent number 5 was, Milord, a public servant.
Understood, but
Yes.
He was a public servant till 2036, 2021.
I think 2016 he was a public servant. No, my lord, one more thing, Lord. Please come to this very affidavit which I am reading. Please come to paragraph 2. Let us see, my lord, who is this petitioner.
Page?
Page 47. Paragraph 3. You have stated something about the petitioner, my lord, that at the very outset, the answering deponent begs to state that the instant proceeding have been initiated by the petitioners for their vested interest and on account of their personal animosity with the answering deponent. The writ petition suffers from gross suppression of material fact.
Paragraph, whose affidavit? Whose affidavit?
That respondent number 5's affidavit.
Oh, this.
Page 4.
Yes.
That at the very outset, answering deponent begs to state that instant proceeding have been initiated by the petitioners for their vested interest and on account of their personal animosity with the answering deponent. Writ petition suffers from gross suppression of material fact. Petitioners have projected themselves as diligent and duty-bound citizens voicing their concern regarding corruption, but they have willfully abstained from disclosing that there are ongoing litigation between petitioner number 2 and the answering deponent's wife. Such litigation include pending arbitral proceeding, so-and-so being this case, and a dispose of application for appointment of arbitrator being so-and-so. The dispute among the parties is regarding allotment of landowner's allocation in an apartment building constructed by a proprietorial concern of wife of the petitioner number 2, who was illegally and fraudulently, which was illegally and taken over by the petitioner number 2, posing as a representative of the answering deponent's wife. So, my lord, petitioner number 2 and my wife, on my wife's land, a building was constructed. That is how all this dispute arose, my lord. And for the allocation of the owner's share, his wife posing himself to be the owner, my lord, too wanted to take the property. So there are ongoing litigations. All these things have been suppressed. It is not out of any, my lord, public interest or anything.
Lordship.
And this fact has not been denied in the affidavit.
Lordship, a reply has rightly been filed and the page number 152 clearly establishes the date on which I have filed the complaint and on date on which the arbitral proceedings has been started. Vigilance and Anti-Corruption officially, Lordship, officially informed the petitioner, respondent number 5, that myself has filed a criminal complaint of disproportionate assets against him in the month of June or July 2019. Lordship, the page number 152 clearly highlights on 27/11/2018, I have filed the complaint at the Vigilance and Anti-Corruption. On 24 January 2019, regular inquiry was ordered by the government. In May 2019, regular inquiry number 9 of 2019 started at Vigilance and Anti-Corruption. And on 12 September, an arbitration case has been filed. The background of the arbitration case is that my wife has intended to sell a flat to my sister-in-law. And in order to stop that flat, they filed the arbitration suit. After the intervention of this honorable court in writ petition number 3008/2020, this sale permission matter has been disposed of, where the respondent number 5's wife was the party. They have not objected there. Neither they have challenged the order of the deputy commissioner where they have filed a complaint against non-issuance of the sale permission. The order was also be there. If the Honorable Lordship want to discuss the arbitral proceedings and entire in the last 5 years, no arbitral proceedings has been started till today. 5 years has been there. Not even they have filed their what their loss they have suffered or their claim. That is only everywhere where these proceedings will come, they will come out. There is a suit against me. Not only me, Lordship, my father, my brothers, everywhere made the party. Everywhere, everyone in my family has been terrorized by respondent number 5 because now, Lordship, please see the order given by Honorable Court on 19/6/2024 in this matter. They have asked the respondent number 4 to produce. Learn senior government will appraise the court the progress, if any, the complaint filed by the petitioner under the Prevention of Corruption Act, in which the Home Department has now filed an affidavit stating that no sanction is required in view of laid down by the Honorable Apex Court in Surendra Kumar Bansal versus State of Punjab. On 19/6, this order was for us, and after 7 days, on 26 June, Mr. D. Nath, learned senior government advocate, produces a copy of communication dated 25/6/2024 issued by the Office of Superintendent of Police, Director of Vigilance and Anti-Corruption Assam, whereby further 4 weeks' time has been requested to submit the instruction as sought earlier by this court by order dated 19/6/2024. 2 months has been passed. Nobody wants to submit anything in the court. Why I am here? Whether my complaint has been logically concluded, an order may be passed. Lordship, in the matter of PV Narasimha Rao, the Constitution Bench has clearly outlined that the competent authority in the matters of MP, MLA, it is the respective speaker. Here the order passed by the Home Department Secretary. How he is the competent authority? The order itself says that the Assembly Secretariat is submitting that permission is not required. And they are issuing an order. Lordship, please see page number 44 of the my petition. Lordship, this is a big scandal. Lordship.
I have seen everything. I'm only asking, if you want a relief from this court, you need to challenge 10/6/2008.
Yes. Lordship, in order
If
to
you
challenge
don't
them-
challenge it, I'm closing your petition. I'm giving you another opportunity.
Lordship, my
I
last-
know,
my
no,
last submission,
no,
Lordship.
nothing more. Enough is enough. I've spent a lot of time. Whether you would like to challenge 10/6/2008.
Yes, I will file an IA challenging.
No
this
IA
order.
business. IA cannot. IA is an interlocutory application. You are to challenge either by way of an amendment of this petition or by way of a fresh writ petition and take that matter along with this.
I will file an amendment in this petition, Lordship.
Don't do that. Why are you not filing a fresh one?
Lordship, because this petition has not been completed by just because of this order.
I understand this petition will remain. I'm not saying disposing of.
Okay,
This
Lordship.
petition will remain. You just file another writ petition. Whatever you are saying, put it on record by way of that this authority has no business out here. This is not the authority by which your the sanction could have been rejected. He has no business. Bring on record the affidavit filed by those respondents to the effect that what do they have to say. Bring on record those, challenge it, and then get that matter tagged with this. With that, this court can set aside 10/6 because your substantive play out here is either to grant appropriate approval, sanction, or rejection. The rejection has already been done. If it was limited only to grant of approval or sanction, I would have or rejection.
Lordship, this is followed by a writ in the form of mandamus or any other writ as deemed fit by the Honorable Court shall not be issued thereby directing the Central Vigilance Commission to inquire into the matter in exercise of its powers under Section 8(1)(f) and take such corrective action as it is empowered under CVC Act as to why the sanction request dated 13/1/2021 has been withheld for 790 days. Lordship, the statutory mandatory is 90 days, Lordship.
Mr. Why you are not understanding? Why you are not looking into the main point? Your point is to put that person, respondent number 5, into the trouble, not other authorities. if respond number 5 is the your eye, which we call it the fish eye, there is no business out there to go into other aspects. Other aspects are, we are not concerned. Your basic thing is this. If you still insist, I can finish up the matter in 5 minutes. To the dictate.
We may so continue, Lordship. We may continue with the leave petition because
Are you going to challenge 10/6/2018 or not?
Lordship, let the court will decide it is a valid order, Lordship.
Okay.
Then only I can only
I will
challenge
pass
this
the
order.
order
Lordship.
now, just now. Heard Miss so and so, the learned petitioner in person. Mr. K. N. Chaudhary, the learned senior counsel, appears on behalf of the respondent number.
With the
Five.
Lordship's kind permission, I'm taking leave, my learned friend.
Mr. D. Nath appears on behalf of the respondent numbers 1, 2, 3, and 4. The case of the petitioner herein is that the petitioner herein is aggrieved by the inaction on the part of the respondent authorities in not granting sanction, in not disposing of the proceedings for grant of a sanction. As regards prosecution of the respondent number 5, which was sought for by the Superintendent of Police, Directorate of Vigilance and Anti-Corruption, Assam. It is seen from the records that during the pendency of the instant writ petition, the sanction has been duly granted. The sanction has been refused. As would be apparent from a perusal of the affidavit filed by the Joint Secretary to the Government of Assam Home and Political Department, dated 24th of July 2023. It is further seen that by the order dated 10/6/2023, the sanction has been refused on the ground that from the investigation it revealed that the respondent number 5 was not the president of the NGO, namely Best Friends Society Nagaon, during the period 2013-14, while the NGO received grant in aid under the ADIP scheme. It was also observed that from the investigation, it was found that the respondent number 5 was not a signatory of any document regarding any receipt or utilization of the fund by the said NGO during the aforesaid period. It was also found upon investigation that the respondent number 5 did not take part in the process of receipt and utilization of the fund received by the NGO Best Friend Society from the Ministry of Social Justice and Empowerment, Government of Assam, under the ADIP scheme in the year 2013-14. Under such circumstances, the sanction which had been sought for as regards allegation, in respect to the allegation of misappropriation of government funds by the respondent number 5, was rejected, was denied. It is seen that pursuant to the said order being passed on 10/6/2023, and the same being brought on record by the affidavit filed by the Joint Secretary to the Government of Assam Home and Political Department in its affidavit dated 24/7/2023, the petitioner have not challenged the said order dated 10/6/2023. This court had asked the petitioner as to whether he would like to challenge, to which he submits that he would not like to challenge the same. Accordingly, the petition stands dismissed.
Lordship, the other prayers has not been considered in
All
the
other, this court, however, further takes note of that the other prayers made in the writ petition being consequential to the first prayer the substantive para, the writ petitions is dismissed. She gave you an opportunity, challenge it, you have a case. But you don't want, I can't help it.
Lordship, the circulars has been submitted along with the Central Vigilance Commission has been grossly violated, and that are the part of the writ petition that has not been considered at all, Lordship.
I can't help you. First, I've asked you to challenge that.
I have filed.
Mr.
Lordship,
go,
I
you-
will challenge this order.
You are
I have
not.
told you, once
You
you
have not
decided that
challenged.
this is a valid order, because this order is not a valid order, that's why
So you don't need to challenge.
this is by issued by an authority who is not competent to do so.
It is done in the name of the governor. The governor never signs a document. Mister, kindly appreciate, this is done by the governor.
Governor is not the competent authority in case of MLA, Lordship. It is the speaker.
So who is going to sign?
It is the speaker.
Who is going to challenge?
Speaker has to be there.
I'll help it.
Thank you, Lordship.
May I please? As per the last order dated 2/8/2024. Or the
Yes, Mr. Bulwa. Your instructions on this?
Can be given some time, the file is misplaced here, because here. After one.
Huh?
Can it be taken after the second one?
See,
Please, your Lordship. Lordship, as per the last order dated 31/7/2024, the Finance Department was to obtain some instructions regarding the sanction of the amount, Lordship. Our land was acquired by the Deputy Commissioner, Lordship, for the construction of the newly constructed building in Ulubari, Lordship.
Twenty-one, Arukuntu? 23 to what?
22. 22.
Well, as per my instruction, well, the proposal is with the finance department now. On 9/8, it has been submitted. And my lord, the proposal is for, my lord, some, it's for granting that, my lord, 2 crores or something, my lord. And when they say, my lord, they will take, it will take some time because from tomorrow, my lord, the assembly will sit, my lord. And can it be on 16th?
Return the land.
My lord?
Return
So
the
it will
land.
be paid, my lord, but
Okay, you agree. Return the land.
it will be on 16th, my lord.
No, nothing. You return the land. You can't keep the land like this.
No, I
I'm
understand. my lord.
asking the deputy commissioner to immediately return the land. You, whenever you have the money, do it. You can't keep the land of somebody, take over the
No,
land of
only, my lord,
somebody.
2 weeks, my lord, let them,
Nothing doing. This is absolutely. You are taking over a land of a
I
person.
understand.
You cannot do that.
No,
And you
no,
have
the
taken things
CAT
for
has submitted
granted.
the proposal.
I asked you to obtain the instruction on 12/8. We are on 21/8. This is
I
happening. Return the land if the finance department doesn't have the sanction.
No difficulties, my lord. Only, my lord, supplementary demand will be considered in the, my lord, assembly session.
If you did not have, why, how did the case of a supplementary demand had come into picture? The question of supplementary demand is not there. You don't even have a demand for having your district establishment. Return the land.
No, it will be, my lord, paid.
Doesn't have funds, we are not concerned.
I understand, my lord. It will be paid from the contingency fund.
You
Now, my
have
lord,
to,
during
you
the
should have
assembly
paid.
session-
You
No.
can't keep somebody's land like this. This is
Well,
a serious
only
case.
for, my lord, another 2 weeks.
And whoever it is, he is to pay the 15% interest. Now pay the requisition expenses. When was the land taken from you?
Lordship, in the year 2022.
20?
22 lordship.
22. From 22 onwards, you pay the requisition and return the land forthwith. Hand over the possession within the next 7 days. List them.
Lordship will kindly, my lord.
No,
Sometime at least let me convey, my lord.
no, nothing.
Clearly, my lord,
Nothing.
difficulties,
You have
my lord,
taken,
from
you,
no,
no, the government has taken things for granted.
Lord.
I made it very clear on the last occasion.
I conveyed to them.
No,
the proposal has
it
been
seems that
submitted
they are.
on 9
This court, by an order dated 23/7/2024, had categorically observed, had categorically deprecated the practice of the government of Assam deprecated the procedure adopted by the government of Assam whereby the land of the petitioners were taken for permanent purpose, that too for construction of a permanent building, by resorting to requisition proceedings, which was nothing but a colorable exercise of power. It is seen further that notification was issued under Section 6(1) of the Act of 1964 for the purpose of acquiring the land. But that too, without making proper arrangement for funds. This aspect of the matter was clear from the affidavit filed by the Joint Secretary to the Government of Assam General Administration Department on 6/5/2024. Wherein it was mentioned that the amount could not be paid, disbursed on account of the financial sanction not received from the Finance Department. It is further seen that as on at the behest of the Finance Department, the head of account was also created on 16/3/2024. And 5 months down the line, till date, there has been no disbursement. Under such circumstances, this court had impleaded the Finance Department of the Government of Assam so that the interest of the government can also be duly taken note of. But however, it is seen that in spite of the orders passed by this court on 23/7/2024, as well as on 31/7/2024, the Finance Department of the Government of Assam is least bothered to grant the financial sanction. This clearly amounts to taking away the land of the petitioner, thereby violating the provisions of Article 300A of the Constitution, which as per the various judicial pronouncements by the Supreme Court, is not only a constitutional right, but also a human right.
One thing, my lord, on 9/8, the proposal has been submitted to the finance department. That at least on that part may be recorded on 9/8. It was submitted by ZAD to the finance department.
You said it has already been submitted as far back as on in the affidavit filed on 6/5/2024.
No, that, there, my lord, no. My lord, I'm making the
That is
statement.
an
my lord.
no, that is an affidavit
quote
filed. No, that is an affidavit filed by the GAD.
It was returned back with that, my lord.
You cannot. That is your lookout. I'm not concerned with all these things.
No, at least my statement may be recorded.
No,
I'm
I'm not
requesting the finance
recording. You
department.
were asked to get your instructions. Nothing you have not there.
So far as
This
the
court
ZAD is
further
concerned,
takes
my lord,
note of
at least my statement may be recorded. I'm referring the finance department.
that on
to the ZAD.
31/7/2024, this court expressed great concern in the delay in the grant of the financial sanction. Inasmuch as such delay would have an impact on the compensation amount as the interest to be paid would be at the rate of 15% per annum. Under such circumstances, this court fixed the matter again on 12/8/2024, on which date the learned standing counsel for the finance department was asked to give an update as to whether the finance department of the government of Assam had granted the sanction.
Here, sorry to interrupt, my lord. On that day, I was supposed to inform this honorable court as per instruction received from GAD that, my lord, on 9/8 they have submitted it to the finance. That's a, my lord, fact. I have got that, my lord, proposal also. On 9/8 they have submitted.
The said matter would not be taken up on 12/8/2024. But after 9 days thereafter, when the matter is taken up today,
Pending.
it has been submitted by Mr. B. Gogoi, the learned counsel, appearing on behalf of the finance department, who is also the standing counsel of the GAD department, that the GAD department had submitted fresh proposals on 9/8/2024 before the finance department.
Well.
The above therefore shows that either the GAD department or the finance department is playing hide and seek with this court and not coming up with the proper instructions. Inasmuch as per the affidavit filed by the Joint Secretary to the Government of Assam, GAD department, on 6/5/2024, the finance department was already moved for the sanction of the amount of rupees 2,16,03,820. And at the behest of the finance department, a head of account was opened on 16/3/2024.
Lord, you will see the annexure to that affidavit, my lord. There it has been stated that they will have to submit a fresh proposal now after opening of the head of account, which they finally, my lord, submitted on 9/8. May I pray Lordship will take up at 2 tomorrow, my lord. It will, no, Lordship will indicate in the order, either return or they will come up with something definite at 2 PM tomorrow. my lord. Lordship will reflect it in the order.
Today, when the matter has been taken up, Mr. B. Gogoi, appearing on behalf of the Finance Department, submits that another 2 weeks' time would be required, taking into account that the assembly proceedings assembly is in
We'll start from tomorrow. my lord.
the assembly. The legislative assembly proceedings would start from tomorrow. The question arises that can the proceedings of the assembly, can the ground of that the assembly proceedings then the ground that the legislative assembly would be functioning from tomorrow be a ground to violate the provisions of Article 300A of the Constitution. More so when the Constitution is the supreme law of the land. In the opinion of this court, such a ground to defer by the Finance Department does not appeal to the conscience of this court. This court fixes this matter again on 13th of September 2024. It is made clear that if the amount is not disbursed to the petitioner, 20 September, is not disbursed to the petitioner in the meantime, the respondent authority shall take immediate steps for handing over the possession of the land to the petitioner. Further consequential orders as regards declaration to the effect for setting aside the acquisition proceedings shall be passed on the next date, if need be. Yes.
Yes, Lordship, we have the instruction.
What is the distance?
The distance is 10 kilometers. It has been shifted to.
Then why you are not having a nearby one? Where will the people go?
Probably not, I have the instruction that there is a river also in between below.
Where?
There is a river from the present setup and between the earlier setup below.
This was issued on 29th of July 2024.
Yes.
Now, as it has been issued, why she is not complying? What actions are you taking? Pursuant to the order dated 2/8/2024, Mr. S. Purwal, the learned junior government advocate, have placed before this court an instruction dated 14th of August 2024, wherein it has been mentioned that the earlier set up Anganwadi Center is situated 10 kilometers away from the present Anganwadi Center. It is also seen that from the instructions that on 29/7/2024, the Anganwadi worker of 195 number Bhura Kattam AWC have been directed to shift the 195 number Bhurakattam AWC to its original survey area within 15 days and report it to the CDPO Rampur within 16th of August. The said instruction is kept on record and marked with the letter X. List the matter again on 9th of September 2024, on which date Mr. S. Purva shall apprise this court as to whether the directions so issued in the communication dated 29/7/2024 have been duly complied. Issued by the Child Development Project Officer, Rampur ICDS Project Kampur,
That's not number 4.
Kamrup, has been duly complied.
Obligation.
May please, Your Lordship.
Mm.
Is it petition in the inaction of the part of the respondent, Lordship?
For what?
We are the erosion affected family and we are possession 1977, Lordship.
What do you want?
We want to settle land, Lordship. And
Huh?
not instruction on no.
Where is your application?
Application is page number, Lordship. Representation, Lordship.
Has the land been de-reserved?
Reserve, Lordship. Page number 26, Lordship. Annexure 1. Paragraph number 4. Page number 26. May I read this, Lordship? This is what 1994, Lordship.
I have the honor to inform you that the proposal for de-reservation so and so.
Paragraph number 4, Lordship.
In this connection, the circle of the SS, the proposal for de-reservation is sent with a Shita copy. This is a proposal. Where is the de-reservation order?
These have not till now, though.
Then, how can it be?
LSC already passed 1994. All the various communication done along with the respondents, Lordship. We are ST tribal as per Jaspal Singh.
What? You are?
ST, Lordship. ST, Lordship, flood affected area, erosion area. Possession from the 1977, Lordship.
You can't de-reserve like this. And where is your application for settlement?
Settlement, Lordship, not available here, Lordship. Last, annexure 12. 12 is a representation, Lordship. Page number 42, Lordship.
Then, the representation can't help you.
All communication mentioned here, Lordship.
You cannot get it. If it is not de-reserved, you cannot get it. You want some other land, very well apply.
Already 77 people are already allotted, Lordship.
Yes, revenue. Throw them out. Those 7 people, because that is absolutely in violation to Jaspal Singh. Who are the persons? Ask the name from Mr. Bora. He will give the names of the 77.
Already next year, Lordship, name is not
Throw
mentioned,
them out.
but already 77 allotted. That is mentioned here, Lordship.
So the allotment register of the 77 one has been read on the VGR land.
MN scheme, Lordship, page number 30, Lordship, annexure 4. Seventy-five families, not 77.
Mr. Bring this on affidavit because this is required to be brought on affidavit so that it may help the petitioner later on. Mr. Esbulwa, the learned counsel appearing on behalf of the district administration submits that he has received the instructions to which he would like to bring the same on record by filing an affidavit. Puts the list the matter again on 18th of September 2024. The affidavit be filed by serving advance copy to the petitioner on or before 13th of September. Take this.
Hello.
And what is the process? Unless you don't de-reserve, you can't. You can't grant the settlement. And they have not even applied also as per the new, as per the policy. You can't, and you bring on record some document because Rule 5 of the settlement rules are very clear. It has to be in a particular format.
My case is as well as lawsuit, Sarkar Nazuri on 2020 GLT passed by this honorable court.
What?
Sarkar Nazrul Islam, the visual land. Visual land and non-visual land lawsuit.
What did they pass?
2023 GLT, one lawsuit.
For what? VGLN, you can't get settlement. So.
I live like it.
Oh. Sir Chopra. Don't have a case.
Lordship, conducting counsel, Mr. V.K. Chopra is suffering from high fever.
Huh?
One date may be accommodated.
We fixed this matter today on the basis of his say. On that day, I was supposed to dismiss.
Yes, sir.
Then?
Sudden high fever has.
He is having?
High fever, yeah. Another counsel, Mr. D. Sahu, sir. Your Honor, Lordship, there's another counsel, Mr. D. Sahu, but he's also in Kolkata today.
Kolkata? What is he doing? That day I was supposed to dismiss, no?
On alternative remedy, on the ground of alternative remedy.
It's challenging which order?
Page 132.
132.
Order dated 27/3/2024.
And the show.
Order in original. One filing. Today also I dismissed one petition. You were not there.
Yes, I was in question for one. Lordship, division bench upheld one, the order passed by your Lordship today, Lordship. Item.
Which one?
The Hotel Atithi matter. Hotel Atithi, but dismiss on the ground. Hotel Atithi, the petitioner. Lordship has dismissed the petition giving liberty them to approach the appellate authority. That order was challenged before division bench.
Oh, Mr. Prukash's matter.
No, Lordship, Mr. Ravi Misra's matter.
Huh?
Ravi Misra's matter. Last week probably order was passed.
When?
After 2 or 3 days. Any date after 2 or 3 days.
31st. Saturday. These type of matters needs to be finished off. The 31st, we finish it off. Whether Mr. Chopra appears or does not appear. If he does not appear, none of you appears, I'll dismiss for default. If you appear, I'll dismiss it on merits, whichever it is. But if you don't appear, if I dismiss for default, you have a big problem. You don't get the limitation. If I dismiss it on this by passing an order, I'll give you 30 days for filing it. Whichever it is, you choose.
Not 31st.
31st. 3/1 8/2024. List.
That also I.
The learned counsel appearing on behalf of the petitioner submits that the counsel, Mr. V.K. Chopra, is not well. Post of taking into account, this court fixes the matter on 31/8/2024, on which date an attempt shall be made to dispose of the matter. Post of. This court further makes it clear that no further adjournment shall be made, are permitted on that date, taking into account that a matter was already heard at length on 5/8/2024.
May I please, Your Lordship? Lordship, we have filed this writ petition praying for direction to appoint special PP and as well as for according proceedings sanction, Lordship.
What do you want?
For according prosecution sanction against the accused. Lordship, on the last occasion, Your Lordship has made an observation as regards the necessary parties that we have not implemented, Lordship. Lordship, now we have obtained an instruction from the petitioner.
Petition's case number so and so. And why prosecution sanction against the accused police officials under 190 should not be accorded. Yes, respondent who is appearing.
Also, we need to file our affidavit, a detailed parawise comments has come in. So
Mr. S. Burua, learned counsel submits that the detailed parawise comments have already been received and the same would be and he would like to file a detailed affidavit in that regard. The parawise comments have been received and he would like to file a detailed affidavit in that regard. List the matter again on 23rd of September 2024. The affidavit be filed by 18th of September.
I'm obliged, Lord.
Lordship, I appear for the petitioner.
Tell me.
36 and 37 Lordship have to be taken up together. 36 and 37 are also.
Formal amendment starts. Lordship, that Finance Act has been notified on 16th of August, amending section 16, inserting section 16(5). Lordship. I have given the relevant page, Lordship.
So in that view of the matter, who are the people who wants to withdraw?
Lordship, I appear for 29, 30, 31 and 35. So except 29, 31, 31, all can be disposed of. 29, 31 will not benefit from this amendment.
29 and 31 would not benefit.
Would not benefit.
But which are the matters which will benefit you?
30, 32 and 35.
Yours is 30.
32 and 35.
35. Yes, anybody from others? Miss? No, you are not benefited. You, all of you will continue to fight. Okay. So we close this 30, 32 and 35. Stating that as you would be, that in view of the Finance Act being notified, you will avail the remedies which are provided therein.
Lordship.
Mr. A. Jain, na?
A. Jain.
The A.K. Jain or A. Jain?
A. Jain, Arun Jain.
The learned counsel appearing on behalf of the petitioner, 30, 32 and 35. Beleg.
If I may correct, that would be 31, Sankha Press Private Limited.
Huh?
31, item number 31, not 32.
Not 30, na? 31.
No, 31 will not close.
31 will not close.
32, my lord, we are not appearing that.
Yes.
32, we are not appearing. But that is a separate matter.
No, it will be 30 and 31, na?
So 29, 30 and 35. Sorry, my lord, so 30 and 35.
Huh?
30 and 35.
Wait. Let us not go by the video conferencing link. Yes,
30 and 35.
30 and 35, not 31.
Not-
30 and 35 to the huh? Mr. Jain, the learned counsel, appearing on behalf of the petitioner, submits that taking into account that the Finance Act 2024 have already been notified, the petitioner would not like to press the instant writ petition, rather would avail the benefits which have been provided in terms with section 16.5 16.5 of the newly amended Central Goods and Service Tax Act 2017. Stop taking into account the above, the instant writ petitions stands closed. Interim orders so passed stands vacated. এতিয়া সেই বস্তুটো দুটাতে বেলেগ বেলেগকে দিব দেই. Yes, now let us hear the others. Tell me.
So
yes, affidavit is being filed by the respondent, number who? Your affidavit has been filed.
In one case, let's see, 12229, we have filed additional affidavit. Lordship may take into.
Where?
In another case, that is not still before Lordship.
You have given copies to others?
Yes, I have given.
Everybody?
Lordship to the petitioners against whom I am appearing, Lords.
Huh?
To the petitioner, counsel of the petitioner against whom I am appearing, Lords.
I didn't get it.
Lordship, I have served the copy to counsel against whom I have been served, a copy has been served to me, Lord.
Okay. Oh, who are there? No, well, Mr.
Ravi
B. N.
Biswa-
Gogoi is there. You have not. No?
No, no. Lordship, I have given service copy to Mr. Betala and Mr. Ravi Misra.
Yes, what do you have to say in view of the affidavit?
Lordship, before I start, in their affidavit, revenue says that there is no requirement for the GST Council recommendation. For a moment, I request Lordship can come to the impugned notification 56 of 2023. They have admitted that there was no recommendation for the GST Council. Just for a moment, Lordships can come to the impugned notification. Serial number 29, I'm holding file, Lordship.
29 is which one? Bogotoki?
Mizo publication, 3661.
Mizo publication. Yes.
Yes. Lordship, page 52.
Yes.
Which may I read? So I start from the beginning. In exercise of the powers conferred by section 168A of the CGST Act 17, read with section 20 of the IGST Act and section 21 of the UTGST Act, and in partial modification of the notifications of the Government of India, Ministry of Finance, number so and so.
On the
published in
recommendation of the council.
On the recommendation of the council. Their notification itself says it is on the recommendation of the council, and now they says that there is no
Now,
recommendation.
what did they say?
They say that there was never a need.
Para? Where?
Lordship, it's at para 89.
Where?
Sorry, page 80, page 84, para 4.15.
4.15, yes.
4.15. page 84 from fifth line.
Hmm.
It is submitted that the recommendations made by the council under section 168A of the Act has a persuasive value, but they does not debar the government to take a decision otherwise than was recommended by the inasmuch as the notification issued under section 168A remains referable to the exercise of the legislative power. The action taken by the government on the advice recommendation of the council is not an administrative action but a legislative action, and the notification issued under section 168A of the Act being legislative in nature, the same can certainly be issued keeping in view the circumstances of the case and the mischief sought to be addressed. In the present case, there was an earlier recommendation by the council, but the government, while exercising the powers under section 168 of the Act, keeping in view the recommendation of the council for the extending the date of limitation, it is submitted that this section 168 of the Act nowhere provides that the recommendation made by the council shall be binding and the government cannot go beyond the recommendation made by the council. Now they say that section 168 does not restrict them, whereas their notification itself says that it has been issued on the recommendation of the council. Now, which is to be believed, lordships, I don't know.
The language is very clear. Let's say page 84, my management read. It is submitted that the recommendation made by the council under section 168A of the Act is persuasive value, but they does not debar the government to take decision otherwise than it was recommended by inasmuch as the notification scheduled under section 160. And with minerals, let's say clarified this position.
Huh?
When then it is stated in the notification, but the legal position is Honorable Supreme Court in Mohit Mineral clarified the entire position lots with regard to whether the recommendation of the council is recommending.
Lordship, I have a different
There are
take.
two aspects.
Yeah.
In the 49th GST meeting, you sought for a larger period of time.
That was reduced.
This period was not accepted.
Yes.
So you initiated on the basis of that, you come up with 9.
9 of 20.
Now, why have you used in the notification on the 56 that with the recommendation?
That is there. Lord.
It's a different thing. On one hand, what Mr. Jain wants to submit, it is a different thing. You may say it to be persuasive value, whatever may be, that it is not binding upon you and all these things. That we very well say. Even a recommendation against it is not binding upon you. You may say that. But why do you say that it is with the recommendation? In 56.
That is
And if there is no recommendation, then wouldn't that be exercise of power wrong? Or wouldn't that be a fraud on the power exercised under 168A?
regarding
Mohit Mineral categorically says, look here, it would be a subordinate legislation.
Yes.
It categorically says whether the GST recommends in a particular manner or not, the GST does not have the power to do so because it is not the legislature who can legislate. And as such, it is in view of that 279B was removed.
Yes.
But the question, however, it is that any other matters, this comes, 168A comes in any other matters which is there in 279. 79(4), isn't that?
279.
4H.
Yes.
4.
A4.
A4.
So A4, that is any other matters will come within the ambit. So if it comes under any other matter, because at that point of time, 168A was never conceived of. It was subsequently done in the year 2020 by way of an ordinance, I suppose, and in Assam there was an ordinance, which may have been later on made a legislative enactment.
Yes.
Now, when you in the categorically mention that there is a requirement and there is a recommendation,
For earlier period it was recommendation.
there is a recommendation for which you are doing it. isn't that a colorable exercise of power? There are two different things. You may very well say that, look here, this recommendation we have sought for, but it was not granted. Last time you said that we have sought for, but it was not granted.
For earlier, yes.
Not granted. And however, in some advisory meeting, you had it, but you wanted to ratify it, you will get it ratified subsequently.
Subsequently, that was the.
You can. Now, tell me one thing. Does 168A of the Central Government Act is similar to the 168A of the AGST Act? You know 168A of the AGST Act?
Expiry material of it.
Can you read the second part of 168 conditions? Can you read the second part of 168? The first portion is okay, then provided.
The power to issue notification under subsection 1 shall include the power to give retrospective effect to such notification.
AGST Act.
Lordship, I'm very sorry to interrupt. In AGST Act, similar perimeter provision has not been inserted. It's only under the CGST Act, not under the AGST Act. I have read the entire all the notification circulars. 168A has not been inserted in AGST Act.
No, there's an ordinance.
It is there, Lordship, it is there.
It is there. It is the ordinance. Kindly see if you want to look into this. Assam Goods and Service Tax Amendment Ordinance 2020. Kindly see the power to issue notification. Audio. Power to issue notification under subsection 1 shall include the power to give retrospective effect to such notification from the date not earlier than date of commencement of this act. So you can still issue a notification giving retrospective effect. Whether ratified or not, that is immaterial. But this power is there.
Okay. Sorry to interrupt in between. Even if the issue, that's my submission, that even if the issue now, it will not serve any purpose because there are Supreme Court judgment which says that if the claim is already dead, then it cannot be revived. So once the time limit has already expired, now
Supreme Court judgment is there. For that, you have to go to Supreme Court, na?
Lordship, in my compilation, I have enclosed that also.
Go to the Supreme Court, then you will get the relief. Now, coming back to the point. So, as of now, order is bad because it's a fraud. May look bad this because the same term is used when you are terming Article 213 as regards the ordinance. If an ordinance is made just to circumvent the provisions of the Constitution or the legislative mandate, it's said to be a fraud on the Constitution. Similarly, wouldn't this be a fraud where you have mentioned that there is a recommendation, wherein it is an admitted stand there is no recommendation?
Second notification, there is no.
It is absolutely a fraud of power. But you can still come up with this notification. But this order which has been passed has to go without the recommendation. Irrespective of not going into the question of force measure and all, whether it will come under the force measure, they have argued to that effect as regards the force measure. They say to that effect that the force measure have been explained in 168A.
Yet it is there. Explanation.
Means war, epidemic, flood, drought, fire, cyclone, earthquake, or any other calamity caused by nature or otherwise affecting the implementation of any of the provisions of this act.
Okay.
As per the case of the petitioners, herein is that it is not, it may include all these elements. The pandemic was there very well. All these things are there. But would it include, would it keep on having a cascading effect, then thereby to trickle down to what limited time? Your basic is that you don't have today the manpower
Yes, that was there.
to
and,
complete.
Heavy lot of work due to.
Have you mentioned that how you are not in a position to do it? With figures, when they question on the question of force measure.
In paragraph 4.2. 4.3. 4.3, page 75. 4.3.
3.
4.3. That it is what file, mentioned that it was felt that there may be
4.3? 4.13.
4.3.
You know 4.3. Page?
Page 75.
4. What is this? And the best part is 4.3 is not here. Oh, yes, yes. Very good. It is worthwhile to mention it is felt that there may be a need to provide additional time to the officers so and so considering the delay in scrutiny assessment and audit due to the after effect of the COVID. Due to COVID-19 officers were badly affected badly. Besides, business was also affected badly, and due to all these reasons, it's difficult to get the requisite done. But then also you have been given 3 years. COVID finished in 2021. Years. How long? Is there any end?
Okay, that's why lot time has been fixed by the notification 9 of 20.
Huh? No, 9 is okay. 9, I'm not touching 9. 9 is okay. Because that is with a recommendation. Yeah, there is, when the recommendation was refused, maybe refused rightly or wrongly, that is another aspect. We are not concerned. But the question is, there is no recommendation at all.
Yes, but not there.
Now, the second aspect is, who has done, when there is a composite thing done, the composite CGST and GST is being done by the state officials.
Okay.
How do you take care of a situation wherein, in view of the government not coming up with a notification, and you can't apply 11.4, say,
In this regard, I've got a specific instruction that by within day or two, that notification will be issued.
which one?
That by adopting all these notifications issued by the central government.
Huh?
That notification will be issued by the state. That we will be adopting whatever notification will be issued by the main.
How can you adopt?
Not adopt, well, it will be applicable to us because.
No, you cannot. There's a reason why you cannot. The reason is because you have unless you amend section 11.1. Unless you amend section 11.1 by way of an ordinance, you cannot.
Because it says only exemption. 11.
That is right. You have to amend 11.1, whereby any notification, you have to say any notification which have been issued by the state shall be applicable. Else, you cannot, because you have the provision of 168A. 168A, which you have incorporated, will put a bar upon you to do that. Now the question is, it's a composite. Now, if the state tax is, the assessment order of the state tax goes, central goes, you can't bifurcate. How do you do that?
If, in view of the latest amendment, probably that speaks that up to 21, registered SCC, they have filed their return up to September 2021. They will be entitled to take all the benefit available to them. So let's see, in view of the same, either notification 56 or 9, always there's no effect now after this amendment laws.
That is only for those 16.4.
16.4, yes, Lordship.
Only for 16. Mr. Jain's case is under section 2B, isn't it?
There's one case under 16(2)(b), and then in one case I have filed returns after November 21. So amendment covers only till November 21. I have filed returns after November 1, so that was not taken care of in the amendment. So that's how it is covered.
Lordship 16.2, that has been clarified by the Honorable Division Bench of our High Court, where it is said that the department can proceed where there is a fraud and other or elements are there. This section has been.
If it is a question of fraud, then obviously the proviso to section 73(1) will take care of it.
Yeah.
There's no quarrel. Unless you come up with a case of fraud. This is not your case of fraud.
No.
You are simply implying section 73(1). Problem arises there. It is parametric to the provision of section 71 of the service tax.
Lordship, allow some time, we'll deal with each case separately.
Huh?
We'll file our affidavit separately in each and every case.
Why?
Considering the merit of each case.
Why?
Because it was.
What merits of a case? It's a question of law.
No.
We are only on 56. 56, you see, if 56 goes, the order goes.
No, Lordship, 56, Lordship, it is with regard to 7310. Time was extended. Time was extended. In this case, Lordship, for financial year 18-19 up to 38th of April 2024. And for financial year 19-20 up to 31st day of August 2024. And latest amendment says that up to 21, those who have filed their return up to September 2021, they will be entitled to take ITC loans. View of the same, the effect of this notification of 56 or 9 has gone, Lordship.
So are you to say that 56 is no longer there in view of that?
View of the latest amendment, there is no effect of either 9 of 20.
That would only apply to those who takes the benefit in view of section 128A. See the new provision of section 128A.
Yes.
That is with regard to.
That is why it says, if anybody's case is pending in appeal or in the writ proceedings and all, they would not be granted benefit from the date.
No, Lordship, that is section 128, where Lordship, the appeals are pending, where interest and penalty has been imposed. That benefit has been given to that not SCC's Lordship, not under section 16. And the case of all the petitioners, Lordship, subject to correction. In my humble submission, all the cases are covered by this new amendment of 16.5.
So are you saying that in view of the amendment being carried out, this period is extended in view of the period is up to 2021, the last date of filing?
Yes.
And as such, it's extended.
Yes. All the SCC has been given benefit. For the up to from 17-18 to 2021. Subject, Lordship, if the return has been filed by 21 September, Lordship.
But who have not been given benefit under section 16(2), what happens?
Lordship, 16(2) says that the persons who has claimed ITC on the basis of document provided by the seller, if then they are not entitled to, because they have to upload their GST 3. If that is not uploaded, then Lordship, our High Court also and different High Courts and even Supreme Court says that if there is a fraud, then we can they will not get entitled to benefit. If their transaction is genuine, then they may be entitled to benefit under section 16(2) laws.
The constitution validity of 16(2) is pending before the High Court.
That has been, Lordship, case has been disposed of.
Disposed?
Yes.
What order has been passed?
Lordship, this order has been passed. I placed order, Lordship, if I have not brought today. In that lordship, honorable division bench on the basis of Supreme Court judgment of 2016 or 15.
Which
No,
one?
that has been upheld by the Supreme Court also.
Which judgment?
That is regard to vet. Delhi High Court passed an order division bench is stating that those, but if the cases are genuine, then they are entitled to benefit under section 16(2). And if the transaction is committed by fraud and others, then they are not entitled to. But the validity was not touched by either different high courts, even Calcutta High Court, Delhi High Court, even Karnataka High Court also.
Judgment says that if lordship, the seller has not paid the taxes, the buyer is not responsible for that. If my transaction is genuine, but if it is fraud, then the department may take action.
Yes.
Lordship, 73 will not be attracted in case of fraud. So these cases are all 73. 74 cases are not before your lordship. All cases are relating to 73.
But 74 is different. 74 is the period is how much?
5 years.
5 years.
5 years. So this is 74.
That will cover
This is
cases of fraud.
74, it will be 5 years.
Yes.
Determination of tax not paid or short paid or erroneously refunded or input credit availed. Now, those persons under 16(2), if they get a benefit, if it is true, then what will happen? Wouldn't that, in view of that, you would be given the benefit?
The Lordship, first and foremost, to my learned friend has to give an undertaking that they will not appeal to Supreme Court and they will give the benefit of division bench order. Secondly, then there is a verification process and for one thing or the other, they may reject. So I am on the show cause notice part, whether I am eligible, not eligible, now it is all secondary. Whether they can issue me a notice or not. Now that is to be decided first.
He is not leaving it.
And anyways, my lordship, in one of my petition, I am anyways not entitled for the division bench order as well as the amendment. Because the returns are filed after November 21. It's in December 21 that I filed. If my learned friend is giving an undertaking, he will allow, I will withdraw. I have no difficulty.
Yes, government, Sam, what do you have to say? You have not filed the affidavit also. You don't want.
For the affidavit part is concerned, I thought I will file it along with that notification if it comes up. Something always, whatever its applicability of these notifications of the central government. So by next week we can, but again, the veracity question will come in, whether procedures point.
Problem arises there.
Yes. Our authority to.
You cannot adopt like that unless you amend 11(1). 11(1), if you amend or come up with a notification under 168(a)(2). That's the only way. It's a different thing. It may be subject matter of challenge is another aspect of the matter, but 168(2) notification may be only thing. But that too without the recommendation, that is goes again. Here his recommendation is to fraud. So we need to complete it. Lot of hearing done. I've understood GST now. When?
Next Tuesday. Next Tuesday. For the convent office, because state has to come with their clients.
It is seen that an affidavit in opposition has been filed by the respondent number 226 in WBC number 1229/2024. That you have not withdrawn, na?
But if I make a statement.
That is Mr. case.
Not withdrawn. The counsels appearing on behalf of the petitioners have been served copies. It has also been submitted that the said affidavit would cover the disputes involved in the instant batch of writ petitions. Taking into account the above, this court fixes this matter. Then, taking into account that the matter have been heard at length, this court fixes this matter on 17th of September 2024 at the top of the list. The parties herein are given the liberty to exchange the pleadings on or before 11th of September 2024. Interim order passed earlier shall continue. Matter
36, 37, 38, 39. Lordship, these are all part of the Lordship series. 36, 37, 38, 39. 35 you have already withdrawn.
30 and 35 is.
And then your matters? You said that.
Obliged.
Last petition, Lordship directed them to take instruction, Lordship, 12-8. Regarding the matter.
Also, in this regard, Lordship, additional deputy commissioner written to the PWD department, Lordship, regarding the facts, and this is some more time, Lordship.
Okay. This court by an order dated 12/8/2024 sought for instructions from the respondent number 3 to 7 as to whether any part of the land belonging to the petitioner have been used for the purpose of construction of the road, and as to whether the said construction is being preceded by any acquisition proceedings. The counsel appearing on behalf of the district administration as well as the PWD submits that instructions are awaited. List this matter again on 6th of September 2024, on which day both the counsels for the respective departments shall obtain the instructions positively.
May I pray, Lordship? Lordship, I am appearing for Karbi Anglong Autonomous Council, Lord. Lordship, I pray some more time to obtain instruction, Lordship. 2 weeks time may be given, Lord.
Yes, who are you?
Lordship, I am appearing for Karbi Anglong Autonomous Council, Lordship. 2 weeks time may be granted, Lordship.
You submitted your representations.
What settlement we have applied?
All of the petitioners.
Yes.
It has been submitted by Mr. R.P. Sharma, the learned counsel appearing, senior counsel appearing on behalf of all the writ petitioners, that each of the writ petitioners have individually submitted representations. Before the respondent number 6. In terms with the order passed by this court on 26/7/2024. The learned counsel appearing on behalf of the Karbi Anglong Autonomous Council submits that further 2 weeks time is required for obtaining the instructions as sought for in the said order dated 26/7/2024. List the matter again on 23rd of September 2024. Interim order passed earlier shall continue.
Duly objected.
Till then, huh?
This matter, also my junior is suffering from viral fever, my lord, to declare the epidemic.
What is this?
I pray for some time, my lord.
My lord, may I kindly see the last order?
Oh, yes.
I was directed to file an affidavit.
You have filed?
I have filed. In fact, my lord, on that last occasion, I could not indicate that the sale deed your lordship wanted from me. It's part of record. It's in the writ petition. Although I have filed along with my affidavit also.
Which one? Deed of sale.
Deed of sale. At page 218. And the schedule your lordship will find at page 224.
Only the land, not the house.
No.
Yes. Mr. GMD.
Yeah, I have not received the instruction. However, there is a notice from the GMC, madam, which will find in the affidavit filed with the private respondent in page number 234. 301 and 2 notice was given. In response to the 301 and 2 notice, the reply is that, well, before that, my lord, there is a notice that in page number 232 seeking documents, whether there is any tax receipt, no certain approved plan. Occupancy, reply is that there is no NOC, and in the next page, 233, my lord. Then we have not obtained any building permission, no objection certificate. No approved plan is there. Building coming up is without any NOC. That's why subsequently the notice.
So you can very well demolish.
My lord, you all have to see, these Assam type houses are there since long time. And the private respondent has admitted, my lord, when he purchased, the petitioners are tenants of the original owner in respect of the 5 Assam type houses.
Where?
At page 205 of the
Page?
page 205 of the affidavit.
Where?
Page 600, during that time
Time
of
of
purchase,
purchase of the aforesaid plot of land by the respondent, the petitioner, as
It is a fact that some type houses were there. I have admitted.
But the Assam type houses were not sold to you.
But, those Assam type houses were in the nature of temporary sheds. So those were there in the land. But now the GMC has found some RCC construction. Against that, they have issued this notice.
I can just produce a photocopy of the place, my lord. Your lordship, fine, my lord, because I have to annex it, my lord, along with my affidavit.
No, you have your rent agreement.
My lord, yes.
Where is
The
the
rent, my lord, we are paying the rent, my lord.
There is a suit pending,
No, 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 read rent agreement.
Long back, my lord, earlier, my lord, it was there. My lord, all houses are, my lord, very old houses. And one shop is there, my lord, there are other civil shops are there, my lord. There is no question of any construction, my lord. They have informed the GMC that we are making construction.
What about the nearby constructions which are there in these things? This photograph, from here, these are, what happened to these?
So
This
these are
is
my lord,
yours.
shops. These are shops.
These shops have,
These shops are also rented out by them, my lord, to different persons. Different persons.
huh?
These are rented out to them by different persons.
No, these are not broken.
No, no. Only backside, my lord, it is broken. I have shown, my lord, that photograph. It is very old, my lord. There is no question of any new construction. That is why, my lord.
But can you, therefore you have to show before this court some document that after, because 1971, after 1971, you were required to obtain permission. If you were having the house prior to that, so there's some document that yes, I was a tenant prior to that in this house.
I'm not claiming 71, my lord. Even after that also, suppose without NOC, some building is constructed, our High Court judgment is there, that if it is within the norms, it cannot.
No.
Yes, and moreover now, the new bylaw has come, my lord. New bylaw also, there is a provision, my lord.
Regarding?
That if the constructions are made, my lord, without NOC also, my lord, it can be.
So 337 has been taken away.
But, my lord, I'm submitting, my lord.
No 337.
337
Amended.
No, madam.
You can demolish without NOC. Even if to my knowledge, if you don't have the permission, then in that case, that cannot be even compounded.
337, there is 337, you have to apply for the NOC. NOC have to be granted by the commissioner. That the building for the building permission. Even if the building permission or boundary wall or whatever it is, any construction, even renovation also you have to get it.
Are they renovating now?
No, not touch at all. That is why I have shown the photograph. my lord.
Okay, we do one thing.
Who said annex?
Your junior is having high fever.
My lord. Hello there.
Even my notice also clearly says that there is an RCC structure.
Huh?
Notice also clearly says
Structure, my lord. I have given the photographs of the all entire houses. There is no RCC.
You just put on affidavit.
Lordship.
What was the structure found and what was it found? You went out there, na?
That's all.
You
Let
see on
along with
record
the
that the
photograph, my lord.
affidavit has been filed by the private respondents. Mr. Esbora submits that he is yet to receive his instructions. During the course of the deliberation, this court and this deliberation, this court, and after hearing both the parties, this court is of the opinion that the GMC shall bring on record their stand by way of an affidavit, and more particularly in respect to what type of construction was actually at the land, in the land which was partly demolished. It's the matter again on how much time? 20 September? 20 September, in time order passed earlier, shall continue till then.
In this case, I was directed to apply instruction. How much time will require to dispose of their appeal?
Oh, this, whatever.
If I require another week's time, because they have written to the concerned officer, but there was some mistake. They was sent to some other ITO.
Can't have the appeal pending for such long.
No, that-
First of all, there is no stay. Something has to be done.
What's it take up on next Thursday? I'll come with that.
Get your instruction positively and ask
Yes.
them to dispose it of.
What-
We give you 2 weeks time. Get them then to dispose. How much time? You give a hearing? Appeal, you have given your arguments also, na?
One appeal, I have given the argument. The other one, they have to ask, they have to send that notice and then I have to submit my.
The second, you have time.
Second, there is time, but.
But the first
penalty
one, there is not, huh?
The penalty is causing the problem. Not, I rely on one judgment of the Kerala High Court, that till the time the appeals are disposed, because they are not disposed in time, the course of proceeding should not be taken up.
You can file an appeal. You can file a stay application before the appeal.
The stay application, they will ask for that 20% that penalty, that the amount has to be deposited. I'm asking.
No. Then also stay is permissible. There are various judicial judgments. There's a constitution. No.
They have to file a
Nothing.
separate stay application, so that is not filed.
Huh?
Stay application has not been filed by.
You should have filed a stay application there. They have the power. Although the provision does not categorically say, but there are provisions to the judgments to the effect that when the power of appeal is there, the power of stay is also there.
There, but generally.
You don't approach there. You have approached that authority, the CIT or whatever may be, the assessing officer, who has passed you, ask you to deposit 25%.
The ITO has asked to deposit. The ITO has asked. No, they cannot have it both ways. Let them dispose it of within that, or lordship may direct within a time frame, perhaps that.
I can, but these are faceless.
Is that it?
Whom should I catch later on if they don't?
It is a difficult. But in.
I can very well otherwise also ensure, if they don't come up, we can very well ensure put the on the CIT. To see to it, because CIT would be the highest official,
Yes.
higher than the Commissioner of Appeals.
My representation also was given to the principal CIT.
The principal CIT, na?
Yes.
To see to it, to
And-
dispose of.
And that recommendation also has to come from him. What we take on Thursday, by that time.
The SC Kyle, the learned counsel appearing on behalf of the Income Tax Department submits that 6-7 days time may be granted to him to obtain the instruction as mentioned in the order dated 9/8/2024. Lists the matter again on 29th of August 2024. No, 30th of August 2024, on which date Mr. S.C. Kyle, the learned counsel, shall positively obtain the instructions. Yes, Mr. Bukas, sir.
Number 3 and 7, 3 and 7 supposed to furnish instruction. We have the instruction notes. We have the instruction. I am filed an additional.
Now, affidavit has been filed by somebody.
I have filed lordship, the bringing on record the.
Bringing on record that those two.
Yes. Bengali one.
Reference to have the honor to.
Nishita Korijandam lordship.
The fact that the ministry.
Yeah. Wait.
So, everything has been published. Nothing remains.
How much lordship?
0.029. Originum also issued.
0.029, but they have what? They have
In the
marked that-
Bengali, there was a mistake. So for that, they have also issued a, what you call, a corrigendum in the newspaper. Huh? Jugasanko.
There is another issue, lordship. The marking they have made, the area comes to 0.0357.
No, that is not the business. they can only take 0.029. If they take more than that, that is another aspect of the matter. They have not taken. It is only 0.029. Matter over.
While taking over position, now it is vested. Now, while taking over position, they will mark up to this, that pillar.
No. I make it clear. They will only take from 0.029. I think. Heard Mr. S.D. Pukasta, the learned counsel appearing on behalf of the petitioner. Mr. N. Goswami appears on behalf of the district administration. Mr. R.K. Talukdar appears on behalf of the
3 and 7, my lord.
NHIDCL.
3 and 7.
K. Fukan appears on behalf of the CGSC. And so appears for the Revenue Department of the Government of Assam. The case of the petitioner herein is that the petitioner is the owner of a plot of land measuring
10 kata.
Huh?
10 kata 5 kata.
Where?
Uh,
Measuring
Paragraph 3, Lordship, page 10. Below. Total 10 kata 5 kata.
measuring 10 kata 5 chotoks 8 gondas in dark number 276/277 of RS Patta number 55, apart from other lands.
Now it will be 295 in secondary spectra.
Huh?
295. That number. Then below also. Has been carved out to 295.
The details of the petitioner in the incident with petition. Okay. Is that in the notification which was published in the English Daily, that is namely Eastern Chronicle, and the Bengali Daily, namely Jugasankha, there was discrepancy in the area of land which have been said to have been acquired from the petitioner. Inasmuch as in the English Daily, it was shown as 0.029 hectares, whereas in the Bengali Daily, it was shown as 0.0029 hectares. In that regard, the petitioner has approached the various authorities for the purpose of making necessary correction by issuance of corrigendum. However, as nothing was done, the petitioner has approached this court. This court, by an order dated 12/8/2024, directed the learned government advocate who was representing the district administration as well as the competent authority to provide instructions as regards the discrepancy in the two newspapers in so far as the notification under Section 3D of the Act of 1956 is concerned. Today, Mr. S. Borua, N. Goswami, the learned counsel appearing on behalf of the district administration, submitted that in the notification, in the Gazette notification number S.O1386 (E) dated 15/3/2024, the quantum of land mentioned is 0.029 hectares. Against the name of the petitioner. This notification was rightly published in the English newspaper, which Eastern Chronicle, on 23/3/2024. However, it is duly admitted that the quantum of land shown here in the Bengali newspaper with Jugasanko was 0.0029 hectares. And it was mentioned that it was a printing error. It has also been mentioned that after the petitioner duly intimated the authorities, a communication was issued to the petitioner on 5th of August 2024 by the competent authority, clarifying that the land which had been acquired from the petitioner in terms with the notification on number 3D, notification under section 3D, dated 15/3/2024, is 0.029 hectares. And there was a inadvertent mistake in the newspaper, namely Jugasanka, published on 23/3/2024, which may be ignored. It is also mentioned that this aspect of the matter was also informed to the NHAI-DCL by another communication dated 9th of July 2024. In addition to that, in the News Daily, Jugasanko, dated 18/8/2024, this corrigendum have been also published. Taking into account the above, this court is of the opinion that the land which have been acquired from the petitioner by the Gazette notification number SO1386E, dated 15/3/2024, is land admeasuring 0.029 hectares under DAG number 295. It is further mentioned, this court further, next quote. This quote, Mr. S.D. Purkaister further submits that although it has been notified that land measuring 0.029 hectares under DAG number 295 have been acquired from the petition, but the respondent authorities have made survey in respect to 0.0375. 0357 hectares. This court is of the opinion that if the acquisition has been made only in respect of 0.029 hectares, the respondent authorities, unless takes appropriate steps under the provisions of law, cannot take over the possession over a larger plot of land than what has been acquired. Under such circumstances, this court observes and directs the respondent authorities to limit the acquisition and the proceedings, as well as limit the possession to be taken from the petitioner in terms with the notification under section 3D issued on 15/3/2024, that is 0.029 hectares. With the above observations, petition stands dismissed. Much obliged. The instruction so placed is kept on record and marked with the letter X. X Guido.
Right, people. But this petition has been transferred from the division bench. Treat it as a.
Not a fit case for PIL. Now,
Treat it as per the.
what is your claim?
My claim was two, my lord, there was two prayer, my lord. First, that to cause a judicial inquiry. To cause a judicial inquiry.
Why?
That was the first prayer. Because the fund which was given for release to the compensation to the petitioners was the disbursing authority is the revenue secretary. And they themselves is also the beneficiaries. Is give a chart of 66 numbers. They are themselves are the beneficiaries of PLD.
Huh?
They themselves are the beneficiaries. They have stated that 66 numbers land belong to them and they are claiming the jirat and everything between themselves. So there we sought for a judicial inquiry.
This is under National Highways Act.
Assam Mala Road. Assam Mala Road.
Assam Mala, unless you have agreement, how can you do that?
That's the second aspect. That's why court will referred it to the single judge, honorable single bench, because of the fact that these petitioners.
Court referred it to the single bench only for the purpose that there was private interest involved, no public interest.
That is the,
Yes,
my lord,
okay.
that
Yes.
private interest.
Indeed.
Private interest is the purchase they have adopted. That we are agreed by the direct purchase method they have adopted. Without any agreement, without settlement, they acquired our land. That is our case. It's a 6 schedule area, my lord, NC Hills. Without any agreement, without any settlement, they have acquired all the lands in violation of Article 21. Clear case, my lord.
Article
1421, my lord.
21, how does 21 come?
The life and liberty, my lord, when they take up. my
Land and liberty, the three. Then what do you say about Article 31, which was removed?
Article 300A is also there, my lord. Property right. my lord.
Anyways, when do you want it?
Any date, my lord, convene your lordship, because this will require some hearing.
Affidavits, pleadings complete?
Everything, my lord.
Everything is complete. The question in this in this writ petition is that the question of the means age of the petitioners, lordship, because before filing of the PIL.
My limited question is pleadings complete.
Completed, my lord.
Taking into account the pleadings are complete, list the matter again on 24th of September 2024, on which date an attempt shall be made to dispose of the writ petition.
Lordship.
Our grievance is from December 23, my lord. Continuously, nothing has been done.
So we are having it on September 24.
Lordship. Deeply.
42 and 43 both. Both same. Obviously.
54 and 55.
Some instruction was sought for lodge, that is not received lodge. Some instruction was sought for lodge, but not received lodge.
What instruction?
Ask the order, lodge. The petitioner in 459116, that is the first item.
These are two
Yes.
against parties.
Yes. The first one, the writ petition filed by me,
Which is Suren Talukdar.
which is Suren Talukdar.
And the other is?
Other is the respondent number 7, who has been included as respondent number 7. He filed a writ petition.
Why?
But because I filed this writ petition against this illegal construction, my lord. over his plot of land, which is a government land. And while he made the construction boundary, he constructed one septic tank adjoining my boundary wall, and he constructed his building in such a way that, my lord, roof of the building, it encroached my boundary wall. So I made a complaint before the authority, GMB.
Where is this? In which place?
It is, my lord, this. Botaguli area. Botaguli area.
Where is it?
Satgaon police station. Under
In
Satgaon.
Assam, I mean Guwahati.
Yes.
TMC, GMDA will come into the picture.
Yes.
Have you made them a party?
They are there.
So will do, then they will have to take permission? No.
Lord, GMDA and the deputy commissioner has already filed their affidavit stating that the land which is in occupation of the respondent number 7 is a government land. And when the authority has issued a notice of eviction to him, then he came and filed this second petition.
Chalo. And there is a stay.
There is a stay. And since 2017, the stay is operating.
And how did the GMDA grant permission?
Permission,
Common lands?
there was no permission.
Without permission, they
Without
have been.
permission.
You are appearing.
I'm in petition, lordship,
In the second one,
Yes, sir.
yes, lordship. Profile-
pleadings complete.
Everything is complete.
Okay. List this matter again on 24th of September, taking into account the pleadings are complete. An attempt shall be made to dispose of both the petitions on the next date.
One thing, if I can indicate, Lord,
Yes.
the deputy commissioner, he was asked to get the record.
Of
The notice, copy of the notice, which is sent to this particular respondent number 7, the other petitioner. And when the instruction came, they said notice was missing. They could not.
Not necessary. Why should he go into whether it is a government land?
Yes, it's a government land. Everything is clear from their affidavit.
Don't need other things. What notice or no notice?
Well, for this issue of notice, this matter,
No notice business. Enough.
5-6 occasions, this matter is.
No. First question is how, if we demolish the house, how are you agreeing whether it is in government land or any land?
56.
We demolish the house. Next time. Yes.
Lordship. Petitioner are the owner of a partial land, my lord. Situated in a market, my lord. Petitioner are the owner of partial land, my lord. Situated in a market, my lord. Petitioner one for demarcation. My lord. That is the only case, my lord. 64 kindly see. You made an application, my lord. It was forwarded to the cycle officer, Lokhipur, my lord.
Nature should not be issued directing the respondents to demarcate the land of the markets and issue a certificate in favor of the petitioners in respect to their lands falls within markets and or direct the respondents to allow the petitioner to collect tolls in the so-and-so weekly market. Still?
And page 66, kindly see, my lord.
Well, he is challenging this impugned order at page 68, settlement order. That has become infructuous now as far as the PNRD department is concerned. Settlement is for 1 year. This settlement order has already lapsed. However, his other prayer is regarding demarcation of lands. His allegation is that the markets are being run on his patta land. So for that, Millet, he had filed a petition before the circle officer requesting demarcation of land. Whether that demarcation exercise has been completed or not, that the circle officer would be in a position to.
But against PNRD, nothing.
He has got no action.
Yes, actually, so maybe directed to demarcate the land. Page 66, there is also, there is a direction also, my lord.
He has
Page
no.
66, my lord.
Why demarcation not done?
That is the only prayer, my lord. Let the cycle officer make the demarcation.
Huh? Why no demarcation done? It's the P border?
P handing, Millet.
P handing, always I mix it. submitted that
The
that
settlement order.
that the writ petition only, the issues in the writ petition only remains as regards the demarcation of the land. And the issue as regards issuance of certificate to the petitioner in respect to their lands falls within the market. Kalisa Bhita weekly market and Kalisa Bhita daily market does not arise, taking into account that the impugn order dated, the order dated 26/6/2019 had already spent its force. Taking into account the above, the counsel for the petitioner fairly also submits that the order dated 26/6/2019 had spent its force, and as such, his limited prayer is as regards demarcation of his land. Mr. N. Goswami, appearing on behalf of the respondent, shall apprise this court on the next date as to what steps have been taken by the circle observer. Which one? Where's your application?
My lord, page 64, my lord.
Huh?
Page 64. Page 62 is
That
the
is to
revert-
the
page-
DC.
Page 62, my lord. Page 62.
No. This type of won't do. We do one thing. Nowadays, they have this office memorandum. We'll finish it off. Calicula, no? Court? List the matter tomorrow at 2. We'll finish it off. As per the office memorandum, na, we'll direct them. Because there is a manner now. I can't direct on the basis this. That's, you must be knowing this, na? And you should know office memorandum. No condition, no? Very good. This one, we have to do it as per this 21st December 2020. Demarcation certificate, procedural steps for issuance of demarcation steps, how it is to be applied.
Published.
We finish it off, asking them to file it in the proper manner. Point keeping these matters.
46 for orders.
Yes. Have you found out how much the petitioner is entitled to?
Yes, Lord.
How much?
This bill amount is
Huh?
197,653. 197,653, Lordship. 97,653, Lordship.
1,93,000
197,653.
he is entitled to. And then now you want to point the blame upon the authority. You are not for the petitioner, you are for the government, na?
We have filed.
You are for the petitioner, respondent.
For the petitioner, Lordship.
Okay, so he said that you are entitled to this much. You have water resource.
Lordship.
You want to involve the Jal Shakti.
Lordship.
Without doing that, that is not possible.
Yes, Lord.
Did you pay your part of it?
Our party is already been paid, Lordship.
Okay. The learned counsel appearing on behalf of the Water Resource Department of the Government of Assam, pursuant to the order passed by this court on 19/6/2024, submits that upon verification, it has been found that the petitioner is further entitled to an amount of rupees.
197,653.
Full stop. You are appearing, no? The issue involved in the instant proceeding is that the review have been sought in the instant proceedings on the ground that as the amount to be paid to the petitioner is on the basis of a scheme where the state government's liability is only limited to 10% and the substantial liability has of 90% is to be paid by the Jal Shakti Department, Department of Jal Shakti, Government of India.
Ministry of
The
Jal-
directions which was passed by this court for payment to the petitioner by the Water Resource Department would have resulted in great difficulty. And it has also been submitted that if the said order is not reviewed, the state government would be unnecessarily burdened, which otherwise is the responsibility of the Ministry of Jal Shakti. Ms. P. Burwal, the learned counsel appearing on behalf of the review petitioner, submits of the respondent, who is appearing on behalf of the writ petitioner, submits that she would like to file an objection. List the matter again on when, how much?
After 2 weeks.
The matter again on 23rd of September 2024. In the meantime, the petitioner would be at liberty to file the reply.
Make this last month.
What is this?
One of the review page,
Why you are seeking review?
what happened, page 81 is the order,
Huh?
Page 81 it starts. The opposite portion, page 84. Last page, para 5,
Yes.
it said it means the court is of the opinion that the instant writ petition. There was order
There is
passed-
an order passed on Iman, thereby staying the order dated. State order continue. Notifications effectively to the people. Yes.
We are only seeking liberty to test the contribution from 2016, as because the ordinate bench of this court has held that the education institution will come under the purview of the ESIC.
Huh?
Education, all the educational institutions comes under the purview of the ESIC, Employees Insurance Corporation, and that there are no assessment should be made retrospectively, that is from 2016, So only at this thing, the assessment can be made only prospectively. That is after the date of judgment of 2/8/2016, You have seeking
2/8?
2016,
Who passed?
That the other order is at page 68, 28/1/2016. Page 72,
Then?
That the operative portion on page 80, Act to cover education institution through the impugn notification dated so and so is found to be in order, and accordingly the contention raised by the petitioner to contrary are rejected.
However, since the operation of the impugned notification was stayed by this court, it should be applied prospectively to the education institution, and no school should be forced to subjugate themselves retrospectively under the ESIC Act in this order.
Right,
My lord, here-
prospectively to the educated,
my lord,
and no school should be subjugate themselves.
prospective.
This order, I passed the same order.
The same order, my lord, in connivance with this, my lord, but here, my lordship is direct to assess from the date of passing of your lordship's order, my lord. That is 2023, my lord.
It should be from
28/1/2016.
from 2000.
28/1/2016, my lord. From the date of the passing of the judgment of the other.
From the date of the instant judgment. So it should be from the date of the,
But the judgment of the earlier. The other petition.
then what is wrong with my order?
Wrong, my lord. Well, only that, we will not be able to recover the earlier orders, my lord, earlier assessment of the petitioners, my lord, of the who was.
No, here also, Justice Rishikesh Roy's order also says from that order only.
28/1/2016, my lord. Madam, your lordship orders from the place of the instant judgment. That will be all, my lord.
Because no, that was passed in that case.
But that was passed in accordance with that case, my lord. But here, my lordship, only one part that should be applied prospectively to the petitioner schools from the date of the instant judgment, meaning, my lord, your lordship judgment, which is
Absolutely.
26.
No, here also he passed that only from his judgment.
My lord.
Because there was a stay.
Here, my lord,
When was the stay vacated?
there was no stay, was not vacated, my lord.
So under here also there was a stay.
There was a stay, my lord.
Thereby staying the order dated demand until further orders, and the said order continued all throughout till today.
Well, I will come to the permanent stay. Is regarding to the notification under section 45A of the ESS. If your lordship may peruse this section, it is only for the period of 5 years that the corporation can assess the contribution, my lord. And in a similar case, my lord, where the other cases was left out, my lord, this court also allowed to assess the contribution from 2016, my lord.
From?
28/1/2016, my lord.
Why?
Because the other cases were left out. So the court has granted liberty to assess contribution of the education institution from 28/1/2016, my lord, in another any another case, my lord.
Understood, but how is it possible? If in that case, whether there was a stay order or not?
There was no stay order, my lord.
Now, in that case, which was the Swadeshi Academy?
There was a stay order, my lord.
So if that stay order was there, how can you apply? See, the question is, can you apply this on that basis that that this court had categorically observed at that point of time that look here, this we are staying this applicability. Now, how do you take that?
This stay order was regarding to the notification dated 2011, which is passed under section 45A of the ESIC Act after giving reasonable opportunity. That period was only for the period of 1 year, my lord. And here under section 45A, my lord, the corporation cannot access the contribution more than 5 years, for more than 5 years. So that period is already gone. So till 2016, that period has already become infructuous. We cannot recover that claim, my lord.
Okay, let us issue notice. Notice returnable by 6 weeks. Steps be taken by way of registered as well as usual.
Yes, ma'am.
48. Yes, complied.
Lordship, we will almost complied, Lordship, that
Huh?
19/8 to 2024, Lordships, that amount has been sanctioned. I always even, my lord, talk with the, my lord, that official of the, my lord, deputy commissioner. On the portal, my lord, it was not seen. My lord, there already been, my lord, amount has been sanctioned to the deputy commissioner.
Sanction has been done on 29/11/2023, but you have not paid.
It is only but it was sent to them.
Sanction is another thing, but you don't pay. The one matter, I'm taking it up with the government.
Take an act matter next week, any day, let's see.
Please, this matter again on 6th of September 2024.
I will produce the documents also.
On which date Mr. J.C. Hendrick, the learned counsel, shall apprise this court as to whether the order dated 16/11/2022 passed by this court in WPC number 4804/2022 have been duly complied with.
Problem.
It's the matter again on icon কিহৰ কাৰণে আছে so? It's the matter to which তারিখে নহয় 29th. List the matter on 29th. 29/8/2020.
Permitted to take justice steps, madam. We have taken, madam, the affidavit has been filed, madam.
Yes, you file your affidavit.
No,
Well,
no, we are repairing for State Bank, madam, 1 and 2. We have been directed by the cyber authority, madam, to stall their account. Only that is the difficulty. I think perhaps they have
all
also
the records mean?
accounts. So some fraudulent activity has been noticed, some amount has been transmitted to their bank account by which one car was purchased. So they have asked,
Understood. Whatever may be, the question is now therefore is whether that you can, if it is only that amount to be concerned, can you stop the entire thing? And whatever the 3 and 4?
info, madam, that had been sent, madam, but they denied to accept it. And thereafter, madam, he marked a mail to them, madam. That mail, madam, today in the morning, madam, at 10:21, have sent a mail that annexing a document in Hindi, madam, that has been addressed to the government advocate of Guwahati High Court, madam.
Okay. We will do one thing. It seems that the Mr. P.K. Muni, the learned counsel appearing on behalf of the petitioner, submits that although an attempt was made to effect service upon the respondent number 1, 2, 3, and 4 by way of the state, but they have refused. Taking into account the above, this court directs the Mr. P.K. Mutini to serve two extra copies of the petition upon Mr. PP. Who's the name of the PP? To Mr. M. Fukon, the learned PP, who shall forward the same to the officer in charge of to the respondent number 3 and 4. Stop. This court fixes this matter again on 13th of September 2024. Stop. In the meantime, the State Bank, who is being duly represented by Mr. A.K. Sahewala, shall bring on record their stand by affidavit.
51.
My lord,
I have already taken justice service. Justice service already, my lord, served, and I have filed additional affidavit, my lord. Running page, my lord, your lordship, kindly see 46. There is office note also, my lord.
Huh?
Office note is there, my lord.
Justice service done.
Done, my lord, completed. I have filed affidavit, my lord. Number 5
You got your instructions? This matter, then this court have duly taken note of the additional affidavit filed.
Running page 46, my lord.
And this court duly takes note of the affidavit of service so filed. And from a perusal thereof, this court deems that the service upon the respondent numbers 5 to 8 is duly complete. Mr. S. Burua, N. Goswami appearing on behalf of the respondent number 1 and 2.
I'm for 1 and 2, madam.
Huh? You are appearing for whom?
Union of India, 1 and 2. I'm for Union of India, railway.
I am for 4.
Mr. S.K. Medi appears on behalf of the respondent number 1 and 2. Mr. N. Goswami appears N. Goswami appearing on behalf of the respondent number 4 submits that he is yet to receive the instructions. Gusto. List the matter again on
After 13, my lord, I will not be available, my lord.
18th of September 2024 at 2 p.m. on which date an attempt shall be made to dispose of the petition. It's a simple matter. It doesn't need much time.
Yes, madam.
Yes, what is this?
The court order dated 5/8/2024, both the petitioner were appeared before the marriage of, and a minor correction was required, and it was done, your lordship. And they have stated that after 1 month, they are going to notify the.
Why the office note has been given? You ordered it here. Oh, yes. What happened?
They will notify the date after 1 month, your lordship.
You have applied?
Have accepted our acknowledgement. Stated that after 1 month, they are it for the intended marriage.
You need only a 1 month notice.
Yes, your lordship. Earlier their statement was that for your marriage, your parents have to be present.
Now, not necessary.
They have stated that after 1 month, we will notify the date for your intended marriage.
You are happy with it?
Definitely, but I have a humble prayer, your lordship, till the closure of their application for intended marriage.
Kept open. Okay. List this manner. When did you go there? 1 month?
Hardly 1 week, your lordship.
1 week, no? So it will be. Okay. List this matter again on 1st of October 2024. On which date the counsels appearing on behalf of both the petitioner and the respondent shall give an apprise as to whether the marriage whether the marriage between the petitioner, both the petitioners have been duly registered.
I'm wrong.